For judgment, item number 1, WPC 1044 of 2009.
Repetition stands dismissed.
May it please, Madam.
Yes, please.
And it's here, the petitioner challenges the award under Annexure 4, whereby the tribunal, my lords, decides that to frame three issues, my lords. My lord decides that the inquiry was conducted in a fair and just manner, but holds that the punishment of termination was extremely harsh, and therefore opines that it could have been taken care of for the negligence that was committed by the workman. It could have been adequately taken care of if 2 increments would have been stopped with a stoppage of 2 increments. But however, goes on to say that instead of ordering a reinstatement, it compounds the compensation at the rate of 20,000, one-time compensation of 20,000. This is what is exactly challenged before your lordship, my lords. I'll just take your lordship, annex page 30, page 30, the findings of the tribunal, page 30, 31 and 32. Lordship may permit me to place just 3 pages. It is an admitted fact that the severity of punishment depends. Lordship has got the page 32. Yes. It's an admitted fact that severity of punishment depends upon gravity of the offence committed. But having regard to the alleged accident, which is minor in nature, the punishment awarded, that is removal from service, appears to be disproportionate to the gravity of the offense committed. But according to the management, since past negligence is operation of the crane by the workmen have been proved by aforesaid documentary evidences on record. The instant one being of a vicious type justifies his termination from service by way of punishment. The management asserts that Shri Patra is a skilled worker and he cannot be allowed to work in any other job, nor can he be degraded, and there was no other alternative. Therefore, the management removing from his services could not have retained him. And the management has also taken a lenient view by not ordering recovery of damages from him. So far as gainful employment is concerned, no evidence is adduced since there is no record produced from the side of the management side to establish that the damage amount of the aforesaid removal from service is not sufficient for the minor accident. He further asserts that he has been working as crane operator for 14 years continuously. He also admits in his cross-examination that in case of electricity power failure, the crane while in operation can be brought to neutral by mechanical devices. According to him, he also managed himself.
So what is your point? It should be not even this punishment should be there, is it? According to you?
No. According to me, since he has been running from pillar to post, my lord, from 76, he has been terminated after working for 14 years, and the award comes in 95. I leave it to your lordship's best judgment, my lords. Some more amount at least, because he was a crane operator, he was a skilled worker. But once this tribunal comes to a finding that it was a too harsh removal was too harsh a punishment.
No, this 20,000 you have received.
20,000, my lords, twice. The record says that twice we have refused to receive.
Then that is up to you. Why did you refuse?
That is the. So I was not have refused. I leave it to your lordship's best judgment. I'll just cite three, my lords, judgments before your lordship, where your lordships have. This is, my lords, the first one is Supreme Court. Year 1958 Supreme Court, my lords, your lordship would find that at para 19. Even in case of para 19 of that judgment, even in case of ordinary contract between master and servant, the considerations have been imported by the courts. The observation of so-and-so in Salt versus Power Plant Company Limited. This is a case of a man who has, according to my view, got an engagement which was to last for life, or at any rate for the joint lives of himself and his company. But I think for his life, because I think there are authorities to the effect that if a company winds up, that is a dismissal of servants, and they can't prove the damages and get their dividends, whatever it may happen to be. Fortunately, the company has not been wound up, but in estimating the damages, of course, the tribunal, estimating them, will have to take into consideration the fact that at any time after 26th January 1935, it might have appeared to the directors that they had good reason for terminating the plaintiff's services, reasons connected with his conduct. The present value of what his salary would be for the rest of his life must also be considered, and there must also be taken into account the fact that he is a man who might at any time terminate his services by his life coming to an end. The other matters which need the industrial tribunal would also have to take into account the present value of what his salary, benefits, etc. would be till he attained the age of superannuation, and value of such benefits would have to be computed as from the date when such reinstatement was ordered under the terms of the award. Then, my lords, the second judgment is of our own High Court. that your lordship will see, this is Agro Industries Corporation versus Bhimsen Manan, the second judgment. There, my lords, your lordship would refer to para 19. Lordship would permit me to place that paragraph, para 19 of that judgment.
Yes.
In the facts of the present case disclose that this is a case of misappropriation of rupees 194. The said amount of 194 was promptly recovered from the opposite party and it was deposited in the corporation's account. What weighed with the labor code while directing reinstatement? Here also there was a dismissal. What weighed with the labor code while directing reinstatement of the opposite party one can be better appreciated from the following observations of the labor code in para 9 of its award. The second party joined the organization of the first party in 1965 and apparently was possessed of an unblemished record of service, as there was no evidence on any past act of misconduct hanging over his head. Here also in our case, my lords, that contention of the management that there was a series of past negligences, there was a finding of the labor code that no documentary evidence of such past misconduct could be produced by the management. It was unfounded by any documentary evidence. He was proceeded against with effect from January 1976 and has suffered for about a decade. He was a low-paid employee and was apparently entrusted with the job of a storekeeper while being paid as junior assistant, a salary of 235 per month. At the time, his services were terminated. It is elicited in the evidence of the workman by the management that he comes from a family of marginal farmers, having 2 acres of agricultural land and his father and 3 other brothers to share.
No, but
In
here,
the
just see this page 28,
page 28
para 7.
of my brief, my lords.
Yes.
My lord. Which part, your lordship?
Para 7, please.
That it is submitted on behalf of the workers that although from the side of the management, a number of documents have been exhibited to show that the second party was either charge sheeted for negligence and received warnings on previous occasions, and several entries in the CCR have also exhibited to show that his performance in the past were not good. Therefore, the removal order is justified. But the workman has denied all these facts and he was never served with such warning notice and communicated with such CCR entries. From the evidence of MW2, personal manager, it transpires that on 3/7/31 he was issued with a warning. That is Exhibit 10, Exhibit 13, Exhibit 15, Exhibit 18, Exhibit 20, and Exhibit 21 are the charges.
So they're all been exhibited.
Charge sheets.
So unlike the decision you are reading, here there are all the documents have been exhibited about the past conduct.
Well, the finding,
Extensive documents are there, CCR entries are there showing poor performance.
I'll
Despite which the labor code has reduced it to stoppage of 2 increments.
Lordship, may kindly turn to page 31, the findings. Towards the end,
Yes.
in the documents exhibited from the side of the management in regard to previous performance of duty, such type of repeated negligence in crane operation did not find corroboration.
That's right. Only
as
for
has been
crane
rightly
operation.
advanced
You
on
see-
behalf of the worker.
Yeah. So for specific crane operation, they may not be negligent. But there have been other instances of poor conduct for which he has been warned, censured, CCRs have been written up.
Well, I leave it to your lordship's best judgment.
Yeah.
I was only that for 19 years.
No, but you refused to receive this 20,000. What does one do then? See, 20,000 had it been put in a FD, it would have earned 6% simple interest. Who's for the management? Who's appearing for sale?
Patnaik's, at least your lordship, at least 25% or any 25% of the back pages, at least 20 or 25.
No, I think 6% simple interest on 20,000 from this is 1995. No, that's will be a substantial sum.
No, but prior to that, man, it's 19
No. What
years.
was the interim order here when you refused? Did you ask them to keep it in fixed deposit at least?
No, that There is no interim order, Manoj.
Ah,
There is no interim order here. There is no interim order, Manoj.
all right. This is the workman's petition against an order dated. Yeah, this is LR submission against an order dated 17 November 1994, passed by the Labour Court, Sambalpur, in ID case number 55 of 19. There's a stamp on it, so I'm not 1990, and an award dated 16/2/1995. Whereby the Labour Court interfered with the punishment awarded by the management of removal of the petitioner workman from service. And substituted it with punishment of stoppage of 2 improvements with cumulative effect. Also, additionally, the Labour Court has awarded the workman compensation in the sum of rupees 20,000. Paragraph. At the outset, it must be noted that during the pendency of the present petition, the sole petitioner died and has been substituted by his legal representatives. Paragraph. Mr. Subir Palit, learned counsel appearing for the petitioner, also informs the court that the petitioners perhaps did not receive and did not accept the compensation of rupees 20,000, which was offered to them pursuant to the impugned award. Full stop. He is also not aware if the said sum has been placed in a fixed deposit in the meanwhile. Paragraph. Despite service of notice and despite a lawyer entering appearance on behalf of the opposite party number 2 management, that is Steel Authority of India Limited, bracket SAIL, today none appears on its behalf. Paragraph. The petitioner workman was a crane operator working with SAIL. Full stop. It was alleged that while he was operating a certain crane in the A shift on 23rd November 1975, he dashed it against another stationary crane, which caused serious damage to the equipment of the said crane. Full stop. This resulted in a loss of production. Full stop. The petitioner was charge sheeted and a preliminary inquiry was held. And a disciplinary inquiry was held. And the petitioner was removed from service. Paragraph. The resultant industrial dispute was referred to the Labour Court for adjudication. Full stop. In the initial order dated 17 November 1994, the Labour Court held that the inquiry was fair as sufficient opportunity had been granted to the workman. Full stop. As far as the main reference is concerned, in the impugned award, the Labour Court has held the punishment awarded to the petitioner of removal from service to be disproportionate and has substituted it in the manner indicated here before. Paragraph. Mr. Palit relied on the decisions in SS Shetty versus Bharat Nidhi Limited, AR 1958 SC 12. Orissa Agro Industries Corporation versus Bhimsen Maharana,
There's one more, Malaj.
1990 HLLN 1149.
There's one more, Malaj. 83 Patna.
Yeah. And B. Chaudhary versus Presiding Officer Labour Court, Jamshedpur, 1983 Lab IC 1755, to urge that the Labour Court should have been less harsh on the kind of punishment awarded ultimately to the petitioner, and perhaps should have awarded a high amount as compensation. Paragraph. The court finds that in the impune award, the Labour Court has discussed the evidence in some detail and has noted that the management produced sufficient document to substantiate the past conduct of the petitioner, for which he had been issued warnings, censures. Also, CCRs were also exhibited before the Labour Court to justify a certain pattern of conduct which persuaded the management to award him the punishment of removal from service. Full stop. Nevertheless, the Labour Court was of the view that the said punishment was disproportionate and substituted with a lenient punishment of stoppage of 2 increments with cumulative effect. Paragraph. Having examined the award in light of the judgments cited by Mr. Padik, the court is not persuaded to hold of compensation. Paragraph. The court might have been persuaded to do so if the petitioner had agreed to receive the amount already awarded. Full stop. Nevertheless, considering that the amount was awarded way back in 1995, the court considers it appropriate to modify it only to the extent of directing that the sum of rupees 20,000 awarded by the Labour Court will be now paid to the legal heirs of the petitioner, together with simple interest at 6% per annum from the date of the award, that is 16/2/1995, till the date of payment, which should not be later than 9th May 2022.
Oblige. Deeply.
The petition is disposed of in the above terms. The LCR, if any, be returned to the Labour Court forthwith for further proceedings.
List item number 2.
So, on the behalf of Ajay Kumar Mahanti, I have not paid, sir. I am a petitioner, sir. I am a petitioner, sir.
All right.
Not paid, sir.
Not pressed. All right. These petitions are disposed of as not pressed.
Weekly list item number 3.
May I please receive my lord. Item 3, my lord. Petitioner challenging the inaction of opposite party number 3, Tahsildar, who is not taking any interest, initiate the ethic encroach of the government land of Silisua village, my lord. My lord, kindly see Annexure 3, last representation dated 14/12/2015, my lord. Last running page 26.
What is the petition number that you are arguing, sir?
My lord.
What is the petition number which you are arguing now? Tell us the petition number.
My lord, next week. My lord, let it come next week, my lord.
Sir, kindly answer the question. If you are you able to hear the question, sir? Are you able to hear us?
My lord.
Are you able to hear us, sir?
My lord,
Yes or no? Are you able to hear us?
my lord, next week come, my lord. I will prepare next week, my
Mr.
lord. Next
Naji,
week.
1 minute. I'll request my colleague to ask you the same question.
Are we audible? What is the repetition number, please?
Repetition number 5035, 2016, my lord.
You're referring the wrong matter. You're taking up a weekly list now. Weekly daily.
Weekly list, item number 3, OJC 6575 of 2002. Item 3.
None appears dismissed from numbers.
Weekly list, item number 4.
May I please? Here, your lords, may cancel the order dated 26/9/2002.
Yes.
My lords, since the order was passed the impugned order was passed on 12/1/2000, and the writ petition was filed in the month of October in the year 2002. So that's why my lords have directed to file an affidavit. Well, verifying that affidavit is not that today I am filing the copy of the said affidavit which was filed in the year 2000. Your lords may peruse that affidavit and pass appropriate order.
All right. You say, by an order dated, he said this is a petition by the state government filed on 26th June 2002. Challenging an order dated 12th January 2000 of the Orissa Administrative Tribunal in OA number 2454 of 1992. Paragraph. By an order dated 26th September 2002, this court had directed the petitioner to file an affidavit to explain the delay in filing the writ petition. Mr. Pursuant thereto, on 23rd March 2005, which is itself more than 3 years after the direction issued by the court, an affidavit was filed seeking to explain the delay. Paragraph. Having perused the affidavit carefully, the court is not convinced that a satisfactory explanation has been offered for the delay in filing the petition. Consequently, the petition is dismissed on the ground of laches. The question of law, if any, is left open for decision in an appropriate case.
Weekly list, item number 5.
My lord, item number 5 has become infructuous.
All right. Counsel, the petitioner states the petition has become infructuous. It is disposed of as such.
Weekly list, item 6.
Item 6, I'm appearing for some of the private opinion parties.
All right. None appears for the petitioner. Dismissal, no prosecution.
Weekly list, item number 7.
None appears. Dismissal, no prosecution.
Weekly list, item number 8.
None appears. Dismissal, no prosecution.
Weekly list, item number 9.
And also I have got the instruction in this case.
Yes, tell us.
Because you know that person is
You're not audible, Mr. Katkia.
I'm sorry, Minos. Big apology. Am I audible now?
Yes.
Because that person is living in his village.
All right. None appears for the appellant. Mr. Katkia, on instruction, states that the appellant is very much present in his village. Stop. Ms. Anita Sahu, whose name is shown in the cause list, appearing for the appellant, does not appear today. Full stop. In the circumstances, a notice is issued to the appellant through the SHO of the concerned police station to appear in person before the court on the next date to explain why his bail should not be cancelled. Meanwhile, the court directs that the registry will furnish to the Secretary, High Court Legal Services Committee, a complete set of the paper book to enable the Secretary to assign a counsel from the panel of the OHCLSC to appear for the appellant. The said counsel will also appear on the next date. Full stop. In the meanwhile, the Secretary OHCLSC will arrange to have the counsel contact the appellant for instructions. List on 2nd May.
Weekly list item number 10.
Item number 10. It has already been settled, my lord. I'm
Alright.
filing a memo.
Counsel of the petitioner states that there's already a settlement. All right.
But yesterday also a batch of cases came, similar matter.
Right. Correct. The petition is disposed of. All right.
Nice.
Weekly list item number 11.
May I please, your lord, similar on behalf of Mr. Vicky Ragada, my lord, we have not received the paper book, my lord. The present appellant already released on bail, my lord, can be taken up next week, my lord. We have not received the paper book.
Receive the paper book meaning what, madam?
And the present appellant already in bail, my lord.
No, what is the meaning of not receive the paper book? You were to collect the copies of the paper book. Nobody is going to come and serve you. You have to go to the registry and collect it. Where is the appellant now, madam?
We could not contact his, my lord.
How do we know if the appellant around or not? Mr. Katke, are you there in this matter?
I am there, boss.
What are your instructions?
So here in this case, boss.
On 21st January.
No, we have not received any instruction.
Yeah, 25th February, the report was that he's hale and hearty. Then we'll ask him to remain personally present, madam. We'll ask the appellant to remain personally present.
We have no instruction. That we
All right. Counsel, the appellant states that she has no instructions on the present status of the appellant. Paragraph. It is seen that in the order dated 25th February 2021, it was recorded by this court on the basis of the report submitted by the IIC Govindpur Police Station that the sole appellant, open quotation, is hale and hearty. Paragraph. In the circumstances, a notice is issued to the appellant through the IIC Govindpur Police Station to appear before the court in person and to explain why his bail should not be cancelled for his bail should not be cancelled. Full stop. Are you continuing to appear for him or should we appoint a legal aid counsel?
Yes, madam. Madam, my senior sir is arguing this matter, madam. We have.
He's appearing?
Yes, madam. Next week, madam.
No. Is he appearing or do you want us to appoint legal aid counsel for the appellant?
No, madam. He's appearing. Yes, yes.
Where is your senior?
Yes, madam. My seniors are arguing this matter, madam.
Just ask him to come, please. We'll pass it over. Please request your senior that the Chief Justice wants to see the senior. All right.
Weekly list item number 12.
May I please, your lordship? I'm on VC, my lord. The first writ petition has been filed by the petitioner management, my lord, challenging the award dated 28/10/2003 passed by the learned presiding officer Labour for Jaipur in ID case number 1 of 2003, wherein the honorable tribunal has directed that the workman promotion will be treated as promotion to the grade A from the date of promotion of Sri B.K. Patra, Sri K.C. Padi and Sri Miss Kalyani Mahapatra, and this workman will be placed above them in the gradation list, and he will not claim or be given any financial benefit in arrear in the promotional post from that date. My lord, the fact of the case is that the petitioner, the second party workman, joined as clerk B on 6/2/1975, and thereafter he became eligible for passing a account examination, which is the qualification as per the regulation we have annexed, my lord, in annexure 1. He became eligible as to appear in the 7th account examination with other 3 employees, my lord. But Sri PC Panda, who is the second workman, they could not pass the account examination, whereas the other candidate passed and they were qualified for the promotion to clerk A, my lord. But thereafter, in 1981, Sri PC Panda again appeared in the account examination and successfully passed the same and became eligible for promotion, my lord. But that OP on 2003, the OP number 2, that is the workman represented through the Vice President Orissa Rajya Vidyut Karmachari, has filed an industrial dispute, raised an industrial dispute alleging that ignoring the promotion of Sri PC Panda and the workman who was working as a senior clerk B to the post of clerk A, while promoting Sri BK Patra, KC Padi, Sri Kalyan Mahapatra, who was junior to the second workman, the second party workman, my lord. The grounds.
Just come to para 4 of the impugned award.
Yes, my lord. Since may be permitted to read out, ma'am.
I am asking you to read out, madam.
Yes, my lord. Yes, my lord. Since the workman has given promotion now, he wants to be placed above the newly added management in the case, and they have not objected to that placing the present workman above. There will not be prejudicial the management. If in the gradation list, this workman will be placed above the workman Sri BK Patra.
This is on a concession. You yourself told the labor court that it will not be prejudicial to the management if Mr. Panda is placed above these 3.
No, my lord. My lord.
No, that is what has been recorded here.
No, my lord. This observation has been taken by the learned tribunal, my lord.
All right, just read on.
If in the gradation list, this workman will be placed above the workman Sri BK Patra, Sri KC Padis, and Sri Kalyani Mahapatra, since from that date it is stated that the workman promoted to the post. But as the workman has not performed his in the promotional post clerk A post in the cadre, he will not be given any financial benefit in the promotional post from the date of promotion of the 3 persons who superseded the present workman. The promotion, though, is not a matter of right, and the court has their limited scope to scrutinize the same, but it is an appropriate case felt by this court to interfere. Moreover, the workman has also filed an affidavit that he will not claim any areas.
Now everybody is superannuated now? All these workers are still working, or have they retired?
Retired, my lord. Retired.
So what survives? Why are you pursuing these matters?
No, my lord. Only
whether somebody is above or below, how does it matter?
My lord, only the regulation, my lord.
No. How does it now matter? All these employees have retired. So if somebody is senior to somebody else, how does it matter now? It has nothing, no dispute survives, madam.
My lord.
Matters of seniority will not survive after persons retire.
Yes, ma'am. He has already got his pensions also. And
then why are you pursuing these matters? One fails to understand why are you people pursuing this?
My lord, only the regulation, my lord.
What will happen? The whole establishment will come to a grinding halt. No, if this regulation, if this award survives.
Yes,
it all depends on the facts of every case, right? They have not struck down the regulation. Who's for the workman?
I am for the workman.
All retired, sir?
Yes, ma'am.
All right.
My lord, I am on the other case, my lord. That is connected case number is, this is one of the case filed by the management, and second one is 4464 of 2005, that is filed by the workman.
What is that for?
Yes, ma'am. In that case, on the basis of this award, my lord, they have giving me promotion. Kindly turn to, my lord, 4464. Annexure 15, my lord, page 46.
Yes.
Para 2. Whereas implementation of the award dated 28th October 2003 of the Learned Labor Code Jaipur passed in ID case number such and such raises a number of legal issues, including the interest seniority of Clerk A of the erstwhile EST Circle Jaipur as on 28th October 2003 on account of said reorganization. Now, therefore, after reconsideration of the matter, this office letter number.
Anyway, this is already stayed by this court.
Yes, ma'am.
So that thing survives.
No, my lord. Question is that they have not given me the financial benefit on the basis of this. That I have awarded, my lord. That is why I have awarded, my lord. My pay was never fixed. Seniority, that order was stayed, but my
no, because the order was stayed by this court.
Yes, my lord.
But so naturally they have to withdraw that.
It was not fixed, my lord.
They can't be faulted for that. Once we stayed it on 8th August. Okay.
My lord.
We stayed the award on 8th August.
Yes, ma'am.
And they passed this order on 17th March itself.
My prayer in this, my writ application, my lord. Therefore, pray that this honorable court would graciously be pleased to consider the above facts and circumstances of the case, issue notice to the opposite parties to show cause as to why the annexure 15 shall not be quashed on the appearance or the non-appearance, and filing or non-filing of the filing insufficient cause may quash annexure 15, and issue proper direction to the opposite parties to bring the pay parity on the basis of the award dated 28th October 2003 and Annexure 7 and their own letters dated 26.
All right.
That is my prayer.
What is the other two petitions? This is one petition, the other two also same. There are two more petitions, no?
No.
Or is there only one more? All right. All
right.
Writ petition civil 71 of 2005 is a petition by the management challenging an award dated 28th October 2003 passed by the Labor Court Jaipur Korapat in industrial dispute case number 1 of 2003. By the said award, the Labor Court ordered that Shri P.C. Panda would be placed senior to Shri B.K. Patra, Shri K.C.H. Padhi and Ms. Kalyani Mahapatra in the post of Clerk A without any claim for arrears in the promotional post. Paragraph. This court had, by the order dated 8th August 2005, directed a stay of the further proceedings. In 2CC, this is the implementation proceedings, is it? 2(C) CC number 9 of 2005, pending the court of the subdivisional magistrate Jaipur Korapat for implementation of the said award. Paragraph. In the long period of 16 years of pendency of the present petition, not only is Shri Panda superannuated, but the other 3 persons above mentioned have also superannuated. Paragraph. Consequently, the court sees no reason why it should interfere with the impugned award at this stage. The concern expressed by counsel for the petitioner that the award might constitute a precedent for other similar claims is allayed by clarifying that the award shall not constitute a precedent for other cases which will obviously be decided on their peculiar facts. Full stop. The impugned orders, the interim orders accordingly vacated and writ petition civil 71 of 2005 is dismissed with the above observations. Then you see WP 4464 of 2005. This is a writ petition by the workman challenging an office order dated 17 March 2005 issued by Grid Court, whereby it decided to cancel the orders issued earlier by way of implementation of the aforementioned award dated 28 October 2003 of the Labour Court. With this court having upheld the said award, the impugned office order dated 17 March 2005 cannot be sustained and is hereby set aside. Full stop. The financial benefits owed to the petitioner, who has now superannuated, will be calculated and appropriate orders be issued for payment of the arrears in terms of the award dated 28 October 2003 of the Labour Court, within a period of 8 weeks from today.
My lord, as there were legal
Right.
issues, my lord, that has been cancelled, my lord. And as per the regulation, he could not pass the account examination.
We've left all those questions, very important questions, we've left them all open, madam. All right.
That has been earlier settled by you.
All right. The petition is disposed of.
Weekly list item number 13.
May pardon, my lord. Item 11, my lord, the criminal appeal for hearing. I press sought adjournment, I request.
Not like this, sir. We follow a certain pattern here. We requested. Are you the senior appearing in the matter?
Mr. Ragada will do this case.
Kindly let us follow some
Yes,
pattern,
yes,
sir.
sorry.
Not walk in whenever
Sorry,
you
sorry.
like and start arguing. Sir.
Pardon.
It's not nice.
In item 13, your lordship. In item 13, your lordship, I'm appearing on behalf of Mr. Buddhadev Rautrai. The brief has been transferred from our office, your lordship. Our opinions may kindly be ignored.
All right. At the request of Mr. J. Biswal, the appearance of Mr. Buddhadev Rautrai is ignored for the petitioner.
No instruction, liberty to file.
Counsel for the petitioner states he has no instructions.
With the liberty to file.
No liberty, sir. It's a 2005 matter. Dismissed as not first.
Weekly list item number 14.
May I please, lordship?
Yes.
My lord, the present appellant.
Yes.
Is aged about now 70 to 75 years, my lord.
All right, sir.
He was convicted under section 302 IPC.
Right, sir.
The occurrence took place in the year 2003.
Yes.
After 11 years in custody, this
Yes.
honorable court
Yes.
released the appellant on bail
Right.
on 22/9/2014.
Right, sir.
My lord, due to altercation between the accused and the appellant,
Yes.
the deceased, the appellant murdered the deceased.
Right.
Thereafter, he was convicted.
Right, sir.
Due to some marital dispute.
Right, sir.
There are 14 witnesses are examined in this case.
Right.
Weekly list item number 17.
Yes, ma'am.
In this case, my submission is that the case was abated due to non-substitution of the case. The case was
You
initially
not
abated.
serve the other side.
It has not been noticed.
No such company exists, sir.
It is a Bhubaneswar company, Atlas company. My lord.
Whatever it is. The report is, have you seen the report, sir? It's in the cause list, it's published, the report.
Yes, yes, my lord.
What does it say, sir? Just show him the cause list.
Yes, my.
All right. In the past 16 years, notice has not been able to be served on opposite party number 2. The notice had already been returned unserved with the report, open quotation, no such company exists in the given address, unquote. The petitioner has not made any effort for finding out the present whereabouts, dismiss or non-prosecution.
Weekly list item number 18.
May I please? Well, it's the substantial question of law as framed. Is with regard to the eligibility of the appellant herein under section 115 JA2 Roman 4, that the power internally consumed, whether it is qualified under section 115 2J.
Sir, has questions been framed already by this court?
Yes, my lord. Yes.
By which order, sir?
The order
2022. Order number 7.
Order number 7 dated 2/2/2022.
I see. Where is this? Not scanned. Why have they not scanned? I'm making a note like this. Please make a note. Yes. Yes, please. Kindly read the question.
My lords, the first substantial question of law is whether in excluding the book of profit derived by the assessee from the generation of power under clause 4 of explanation to section 115 JA2 of the Income Tax Act 1961, the profit is to be computed on the basis of realizable value of such power which has been utilized by the smelter unit of the manufacturing aluminum. This is the first. And the second, where on the facts and in the circumstances of the case, the tribunal was justified in law in not allowing the entire claim for leave encashment and post-retirement medical benefit, which has been determined as an accrued liability and computed on the basis of actual valuation.
All right. Yes.
Now, my lords,
what does the tribunal say, sir, on both these questions?
the tribunal at page, so far as the first substantial question of law is concerned, the tribunal at page at page 112 dismissed our first ground, paragraph 113. After considering, may I permit it to place my
1 minute, please. No. What's the discussion?
112, paragraph 112, running phase 111, internal phase 41. Start from we consider the rival submission.
Yes.
May I please? We have considered the rival submissions made by both the sides and perused the orders of the authorities below. We find that as for provisions of section 115 JA2 Roman 4, the book profit is to be reduced by amount of profit by an industrial undertaking from the business of generation and distribution of power. The above provision does not mean that a person can sell to himself. We find that the learned CIT, while deciding the issue, has considered the various case decisions relied upon by the appellant and has passed the order. The relevant para of his order at para 20.3 reads as I have given careful consideration to the order of AO and the submissions made by the appellant company while computing the book profit under section 115J of the Income Tax Act 1961. The book profit is to be reduced by the amount of profit derived by an industrial undertaking from the business of generation and distribution of power. As for clause 4 below, second proviso to subsection 2 of the above section, the appellant company has a CPP. The power generated in the CPP is principally consumed by the appellant company itself. It has also sold some power to Gridco for rupees 75.75 crores. The issue to be determined here is how to compute the profit from the CPP, which has to be excluded while computing the book of profit under section 115J. More precisely, whether the profit has to be determined only with reference to the power actually sold to Gridco, or the determination of profit would also encompass the power generated and consumed internally, as contended by the appellant company. The words derived by used in clause 4 cannot have a wide import so as to include any income which can in some manner be attributed to the business. The profits derived by the eligible business has to be mean profit and gains includable in the computation of total income chargeable to tax. In this case, it will be difficult to hold that the appellant has derived profit from internal consumption of power. As the AO has rightly observed, one cannot sell to himself and derive profit. Therefore, what appellant company is advocating for exclusion is the fictional profit. Such fictional profit has to be determined by drawing up another set of accounts by presuming non-existent sale at an assumed rate. Section 115J does not visualize the exclusion of profit determined notionally on the basis of certain assumptions. What it seeks to exclude is the profit derived from eligible business and included in the book profit as such. Reliance in this regard is based in the ratio of decision of Allahabad High Court in CIT versus Hind Lamps, so and so, rendered in the context of Section 80J Roman 1. The decision in this case, in the case of Anil Stark Products Limited, relied upon by the appellant, is not a judgment directly on the issue. After considering
What is this Hind lamp say? You have a copy of this Hind lamp?
No, ma'am.
Hind lamp, on the question of 80J1.
No, 1 minute, sir. We are just asking him
Sorry,
something.
I do not have a copy of that judgment.
It helps you, but you do not have a copy.
No, I have other judgments that I have given.
I see.
Before my lords, the first judgment is of the Supreme Court, that is of the year 2008.
Yes.
My lord, before answering the first substantial question of law, my lord, may kindly turn to chapter 12B of the Income Tax Act.
Yes.
This is a special provision relating to certain companies.
Yes.
Now, my lords, in this very context of the matter, the Honorable Supreme Court has an occasion to interpret the provisions of 115JA.
Right.
The assessment year before my lords is relating to the year 1997 and 98, and before the Supreme Court the year is also same. But the difference is with regard to the deduction claim under 115JA2C. Now, my lord, the assessing officer, the very second paragraph, may I permitted to place my?
Yes, please.
In the civil appeal, we are concerned with the assessment year 97-98. Assessee company has engaged in trading data communication equipment and satellite communication services. During the course of assessment proceedings, the AO found that the assessee had debited an amount of 92,15,187 on account of bad debts to the profit and loss account. However, on the ground it was a provision for bad and doubtful debts, the AO added aforesaid amount to the book of profit as for explanation C to section 115JA of the Income Tax Act 1961. On appeal, the CIT allowed the assessee's appeal. That decision of CIT stood affirmed by the tribunal and also by the High Court.
This is not helpful in understanding the word derived by.
No, it's not about the word derived. It is the power of AO to go in the assessment.
That's all right. That's not the question here, sir. The question here is, how do you understand profits derived by? Do you have to exclude the captive power consumption? Because that is something internal to you. What the AO seems to say is that you can't sell power to yourself.
That has been
so you cannot expect to compute profits by having a notional amount which you would have spent had you not captively consumed the power. He says since that notional concept is not there, you only have to go by the power that you actually sold to Gridco and not the power you consumed yourself. Correct?
My lords.
Now, so for that, what is the relevant decision?
That the second decision of Delhi High Court I am given.
Let's see that.
That is also of the year assessment year 97-98, that the judgment is dated 21/11/2008. Second.
But this is provision for bad and doubtful debt, sir.
No, it is the second decision, Delhi High Court.
Delhi High Court also.
No, my lords. The substantial question of law.
Let's read the first substantial question.
The second page, my lords. Whether the income tax appellate tribunal is correct.
Second question. All right. Generation of power.
Yes.
How is this answered?
The issue is answered, my lord. My find at page paragraph 14.
Yes.
In view of the discussions above, we hold that the assessee is entitled to reduce the book of profit from
So
the
you
profit.
read that para 13 then.
13.
Yeah.
This brings us to second contention as to whether the assessee is in the business of generation of power. Based on the finding returned both by the CIT as well as the tribunal, it cannot be said that the assessee is not engaged in the business. As rightly held by the tribunal, the assessee had been authorized by the state electricity board to generate electricity. The generation of electricity has been undertaken by the assessee by setting up a fully independent and independent industrial undertaking. These undertakings have separate and independent infrastructures, which are managed independently and whose accounts are prepared and maintained separately and subject to audit. The term business, which prefixes generation of power in clause 4 of the explanation to section 115J, is not limited to one which is prosecuted only by engaging with an outside third party.
Right.
The meaning of the word business, as defined in section 2B of the Act, includes any trade, commerce, manufacture, or any adventure or concern in the nature of trade, commerce, or manufacture. The definition of business, which is inclusive, clearly brings within its ambit the activity undertaken by the assessee, which is captive generation of power for its own purpose. The approach of the CIT and consequently the tribunal, both in law and facts, cannot be faulted.
So there they held it in favor of the assessee and the revenue was in appeal.
Yes, yes.
So this squarely applies. This judgment squarely applies. It's in your favor.
Not the second contention is with regard to the interpretation of the second substantial question of law that my lord has framed with regard to the post-retirement and leave encashment benefits.
Correct.
In that context of the matter, my lord, what I am citing the judgment that is rendered by the Honorable Supreme Court in the year 2008. This relates to a specific provision, interpretation of the specific provision under chapter 12B, which is with regard to special provisions relating to certain companies. In that perspective, the matter of the Supreme Court has clearly held that the assessing officer cannot go beyond what has been done. Now, in this case, the assessing officer, which is the base of the order, has totally disallowed our entire claim under the post-retirement and leave encashment benefits. And the same has been affirmed by the learned ITAT.
Yes, what do you say?
So far as judgment is concerned, I have to check whether department challenges the Supreme Court.
That's okay. If it is challenged or not, that's all right, sir. We're not adjourning for those purposes.
No, I'm not. I'm saying I'm only seeking not one.
No adjournment, Mr. Satpathy. Forget the adjournments. Yes.
Milord, he has to say apply the judgment. I have to check it, not whether.
We'll supply you. No problem. Yeah.
And second, in the second part is not the tribunal has allowed to.
Are you interested in the judgment? We can give you a copy.
Yeah, just now giving.
All right. Squarely covered, Mr. Satpathy.
Yes, Milord.
Squarely
That I understand, Robert. Right.
And the reasoning is perfect.
Yes, yes. But a second question that is answered in the tribunal and the allowed in said that in page 114.
Yes.
In running page 114, they are allowed the actual for we further find CIT was deciding the issue was considered the decision in case of Bharat Atma Private Limited and has directed the AO to allow the deduction when computing the books profit under 115JA on the account of liability of leave encashment determined accurately for the previous year only. He has claimed total. He has been directed to allow on previous year only. That is
no, which is why he's referring to this 2008 Supreme Court.
Yes.
To say that these are special kinds of companies.
company and
You can't disbelieve the accounts in such companies. That's
But
what the
this-
Supreme Court has held.
but the section says 115JC,
Yes.
the amount or amount set as the provision made meeting the liability other than ascertain liabilities.
Right.
So it is ascertain liability, not in the actual basis.
Yes.
If the section says not that in actual basis, it should be allowed in the actual basis, and tribunal and CIT has rightly answered in the question and directed to allow this previous year only, whatever he has paid, credited.
All right. What do you say to this last submission, sir?
The last submission, my lord, since the assessing officer cannot go beyond what has been.
No, he says under the provision itself, it can be only on actual basis and not on accrued basis. Where's the provision?
But 115J subclause C for the explanation.
We are in 115JA, correct?
Yes.
Ah.
Explanation for the purpose of section books means, may I please?
Yes.
Net profit as shown in the profit and loss account of the relevant previous year prepared under section 2 in the increase by A to B sub C. The amount or amount set aside or provision made for meeting the liabilities other than certain liabilities. That is the provision under which he has claimed the deduction. That is also the finding of the tribunal also.
No, increased by.
Sorry.
It is increased by the amount or amount set aside to provisions made for meeting liabilities other than.
Other than.
So even accrued, whatever is for accrued purposes also will be increased by.
Other than certain liabilities.
That's right.
So therefore, my lord, what is actually paid in the previous year, that has been directed to be allowed.
What do you say, sir?
My lords, in that context, my lords, we have stated in para 24 that page 11, according to the petitioners, accounted for the liability for leave encashment benefit and post-retirement medical benefits up to the accounting year 96-97 by debiting the same to the profit and loss account of the actual variation basis. So amount has already been debited. And in view of the decision of the Honorable Supreme Court, since the AO cannot go beyond what has been stated.
So even that, according to you, is ascertained. No, is it ascertained or not is the question. So if it is an ascertained thing, then it will be included. So on the basis of actuarial valuation, they've already set aside the amount.
They have allowed it only for the
previous year.
Previous year.
All right. You see, this is an appeal by NALCO against an order dated 30th November 2005, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT80, in ITA number 459/CTK/2003, with the assessment year, bracket AY 1997-98. While admitting this appeal on 2nd February 2022, the following questions of law were framed for consideration. Reproduce 2 questions. And then you say, question 1. Below that, you say the background facts of that. The appellant assessee is a Government of India enterprise engaged in the business of mining, manufacturing, production, generation, and dealing in bauxite, aluminium, and power, operating under the Ministry of Mines, Government of India. Full stop. The assessee follows the mercantile system of accounting, and its accounts are maintained on the accrual system. Full stop. Paragraph. The profit and loss account, bracket P&L, account of the SSC has been drawn up in accordance with the provisions contained in parts Roman capital 2 and 3 of Schedule 6 to the Companies Act, and after the same is scrutinized and certified by the statutory auditors as well as by the Comptroller and Auditor General of India (CAG), it is approved by the petitioner in its general meeting and thereafter filed with the Registrar of Companies as required under the Companies Act 1956. Paragraph. It is not in dispute that the petitioner is liable to single quotes minimum alternative tax (MAT) tax under section 115J capital A of the Income Tax Act 1961 Act based on its single quotes book profits unquote. Full stop. For the AY in question, on account of brought forward depreciation and investment allowance, the taxable income of the SSC was single quotes nil, and therefore this attracted the MAT tax under section 115 J A of the Act. Paragraph. The petitioner generates power in its captive power plant (CPP) at Anugul. Full stop. The power so generated is internally consumed in its smelter plant at Anugul for the production of aluminum. Full stop. Surplus power is sold by the SSC to Gridco. Paragraph. According to the SSC, the CPP is separate and independent accounting unit, and separate books of accounts are maintained for transactions of the CPP, and profit and loss from the CPP is separately computed. Full stop. The profit for a year, as shown in the P&L account of the SSC, is stated to be the sum total of the profit / loss from its different accounting / functional units, namely mines, alumina refinery, smelter, CPP, and so on. Paragraph. The question that arose before the assessing officer (AO), who picked up the return of the petitioner for scrutiny, was the manner in which profit derived from power generation referred to as single quotes power profit unquote is to be reduced from the book profits. Full stop. According to the petitioner, the profit derived from power generation at its CPP, being power profit, is eligible for deduction under section 115 J A (2) Roman small 4 of the Act in computing the taxable book profits under the said provision. Paragraph. The further question that arose is whether power profits are to be determined on the basis of the single quotes realizable price unquote, that is the price at which power is sold to Gridco. The AO, however, while assessing the SSE to MAT tax under section 115JA, in computing the book profits, disallowed the claim of power profits by rupees 32.754 crores. Full stop. The SSE then went in appeal before the Commissioner of Income Tax (Appeals) -2 Bhubaneswar (CIT) (A). The full stop, who upheld the disallowance made by the AO. Paragraph. After the further appeal before the ITAT on this aspect was rejected by the impugned order, the present appeal has been filed. By the ITAT, the present appeal has been filed. Paragraph. Mr. Sudipta Kumar Singh, learned counsel appearing on behalf of the appellant SSE, has drawn the attention of the court to a judgment of the Delhi High Court dated 21st November 2008 in ITA number 1187 of 2005, Commissioner of Income Tax, Delhi 4 versus Messrs. DCM Shriram Consolidated Limited, to urge that power profit cannot be determined by excluding the component of power generated and consumed by the SSE. On the other hand, Mr. Satpathy, learned standing counsel appearing for the department, supported the view of the CITA, which has been endorsed in toto by the ITAT. Paragraph. The above submissions have been considered. The CITA has, in the order dismissing the SSE's appeal, gone by the logic of the SSE not being able to sell power to itself and derive profit. Full stop. It was held that the words single quotes derived by used in clause Roman small 4 cannot have a wide import so as to include any income which can in some manner be attributed to the business. Full stop. The profits derived by the eligible business has to mean profit and gains includable in the computation of total income chargeable to tax. Unquote. It was held that, open quotation, it would be difficult to hold that the appellant has derived profit from internal consumption of power. Unquote. The ITAT has adopted the above reasoning in toto and observed that section 115JA (2) (4) of the Act, open quotation, does not mean that a person can sell to himself. Unquote. Paragraph. The relevant portion of section 115JA (2) (4) of the Act reads as under. So first take out 115JA, then bracket 2, and then bracket 4. up to type the whole thing up to 4. In almost similar circumstances, the Delhi High Court in Messrs. DCM Sriram Consolidated Limited Supra considered the question whether an SSE would be entitled to reduce the book profits to the extent of power profit derived from its CPPs while computing MAT under Section 115JA of the Act. Full stop. The similar argument was advanced by the revenue before the Delhi High Court, namely that there was no sale inasmuch as the transfer of power was not to a third party, and consequently, open quotation, no profits could have been earned by the SSE. Unquote. Further, it was argued, just as it is argued in the present case, the main line of activity of the SSE is not the business of generation of power, and that there is no mechanism for computing the sale price, and consequently the profit which would be derived on transfer of energy from the SSE's CPPs to its other units. Full stop. As far as the first contention is concerned, the Delhi High Court referred to the decision of the Supreme Court of India
That's it. May I?
in Tata Iron Steel Company Limited versus CIT 48 ITR 123. It was concluded by the Delhi High Court on the basis of the above decision that, let's say A to A, then B to B. In fact, there's a Orissa High Court decision that's been referred to. I mean, Orissa Cement decision. So A to A, B to B. Paragraph. On the issue whether the SSE could be denied the power profits as computed by it on the ground that power generation was not its main line of business. The Delhi High Court held C to C. Court concurs with the interpretation placed on the expression single quotes business used in section 2 small b of the Act, and holds that the SSC here is entitled to reduce from its book profits the profits derived from CPPs in determining the MAT payable for the purpose of section 115J bracket capital A of the Act. Question number 1 is therefore answered. In favor of the SSC and against the department. By holding that the AO, the CITA, as well as the ITAT erred in law and not allowing the claim of the SSC of rupees 45, 48, 73, 179 as deduction under section 115J824 of the Act relating to single quotes power profits. Paragraph. As regards issue number 2, up to the accounting year 1995-96, the SSC was not providing any liability towards leave encashment and post-retirement medical benefits to its employees. Full stop. On account of the comments of the qualification by the CAG under section 619 bracket 4 of the Companies Act, and on account of the accounting standard 15 issued by the Institute of Chartered Accountants of India, read with the amendments to section 145 of the Act, the SSC, with effect from AY 1997-98, was required to make and single quotes actuarial valuation, close quotes, in respect of the said leave encashment and post-retirement medical benefits. Full stop. Based on such single quotes actuarial valuation, quote, the SSC charged to its P&L account rupees 441.28 lakhs during the accounting year 96-97 as liability towards the said leave encashment and post-retirement medical benefits. Full stop. Paragraph. The AO has treated the liability of rupees 441 lakhs on the above ground as a contingent liability and added it to the book profits. Full stop. This has been upheld by the CITA and the ITAT. Paragraph. Mr. Singh, learned counsel appearing for the SSC, placed reliance on the judgment of the Supreme Court dated 23rd September 2008 in civil appeal number 500 of 2000 bracket Commission of Income Tax versus HCL Comnet Systems and Services Limited to urge that since chapter 12-B has contains special provisions relating to companies for which single quotes deemed income, unquote, is to be determined under section 115JA for the purposes of MAT, comma, the manner of treating certain liabilities on accrual basis by using the actuarial system should be accepted as, and single quotes, ascertained liability, unquote. Mr. T.K. Satpathy, paragraph, Mr. T.K. Satpathy, standing counsel, on the other hand, referred to clause small c of the explanation below section 115J capital A bracket 2 of the Act and submitted that single quotes ascertained liabilities, unquote, that is, only the amount actually paid will be eligible for deduction from the profits for arriving at the book profits on which MAT has to be paid. He accordingly submitted that the AO is justified in allowing only such amount that is payable on this, that is actually paid on the score in the previous year, and not the entire amount as claimed by the SSC. Paragraph. Having considered the above submissions, the court is of the view that the reasoning of the Supreme Court of India in HCL Cognate Systems and Services Limited should prevail. Stop. The Supreme Court there was considering for the purposes of section 115JA bracket explanations comma explanation bracket small c comma whether the provision for bad and doubtful debts as claimed by the SSC should be treated as in single quotes ascertained, unquote, or in single quotes unascertained, unquote, liability. Full stop. In that context, it was observed as under, let's say, D to D. On the same, adopting the same reasoning, as far as the present case is concerned, the SSC's treatment of the liability in respect of the post-retirement and medical benefits as reflected in its P&L account should be accepted by the department and cannot be questioned. Stop. Consequently, question number 2 is answered in the negative by holding that the ITAT was not justified in not allowing the entire claim for leave encashment and post-retirement medical benefit determined as an accrued liability and computed on the basis of actuarial valuation. Paragraph. The impugned orders of the ITAT and the corresponding orders of the CITA and the AO on the above two issues are accordingly set aside. The appeal is allowed, but in the circumstances, no access to costs.
Weekly list item 19.
On item 19, matter relates to Waqf property, where actually the tribunal's order is the subject matter of challenge under section 83 within bracket 9 of the Act.
Yes.
But the interim order was there since 2007.
Right.
But here the difficulty is one that the petitioners, two petitioners have died because they the mutwalis, hereditary mutwalis, in respect of property. The suit filed by the respondent dismissed.
Right.
Court held that the earlier suit filed by them has been dismissed. They didn't restore it. Therefore, the subsequent suit, which has been filed before the Waqf tribunal, is also liable to be dismissed.
Right.
The claim was to declare it to be a private property of the defendants, and they are the mutwalis.
Right.
Court dismissed it without considering their hereditary right. But they are still continuing to be heritors, and the generations after generations, all the documents are there. But since they have two of the persons died, but I think it is required to be substituted. They died recently, 2 months ago. So I be allowed to substitute them. So
all right. Mr. Mishra, senior counsel appealing for petitioners, informs the court that only 2 months ago, petitioners 1 and 2 have expired, is it?
Yes, yes. No, petitioners, I'm sorry. Petitioner number 5 and 6.
Okay, petitioners 5 and 6 have expired, and their legal representatives are required to be brought on record. List on 27 June.
Madam.
Weekly list item. Weekly list item number 20.
Item 20, your lordship, since long, we have no instruction. Your lordship may be dispose of the matter.
All right. No instructions disposed.
Weekly list item 21.
Interim order to continue.
All right. That earlier might be interim.
May I please, madam?
21.
May I please, madam?
Yes.
So, leave to appeal laws. In this case, the accused persons were charged.
List item 22.
Item 22, my lord, kindly pass over.
All right, pass over.
Weekly list item 23.
23, pray for a pass over on behalf of Mr. Mishra.
All right.
Weekly list item 24.
24, my lord. I'm appearing for the workman, my lord. My this case is pending. That is 474.
1 minute, sir. Who's for the petitioner?
Mr. Mishra is the petitioner.
Yes, Mr. Mishra. Is he
My
here?
lords, I am petitioner. Yes, your lordship. Little problem with my net, your lordship.
All right.
Your lordship, I have tried to prepare a short chart for your lordship, but it's not ready today. But the matter is very simple, and it is within your lordship's grasp also. Relates to the domestic inquiry and a case of termination.
Right.
And a bank employee, special assistant, making 50 CS entries in the bank records.
Right.
Then charge sheet, then disciplinary inquiry followed, and he has been report has been given against him. Then second show cause notice issued, personal hearing also given. Thereafter, dismissal was made.
Right.
And he has raised this reference is peculiarly made, your lordship. Your lordship may kindly have a grant. If your lordships permit me, so that I can give a written note within 2-3 days, your lordship will hear it. What has happened here, your lordship, that the inquiry, the learned tribunal, while deciding the reference, he has initially said that we'll be deciding the issue number 2, that is domestic inquiry at the first instance, and evidence was laid on that respect only. But ultimately, without he answering that, your lordship, he has answered. He passed the award on all issues, your lordship. That is the short point, your lordship.
That is no I think last month or the 2 months ago.
Yes, your lordship.
Passed
Come across such a case, I think Mr. Mishra was given. Has your lordship passed a judgment, your lordship?
Yes, we've said that should not make us again go through the whole exercise of again sending it back to the labor court.
No, that is right, because I will be drawing your kind attention to Divyas Pandit's case. The facts in this case completely agree, tallies with that case before the Honorable Apex Court, your lordship.
Right.
I'll place that judgment, your lordship. Give permits 2-3 days time. I can prepare a note.
No, but there is a judgment.
And I'll also check up
given on this.
Your lordship's decision also, if I can be helped, your lordship, give a reference, your lordship, so that I can check up that.
That was only last month, so I don't know where. Only last month.
Last month, your lordship. I'll check up, your lordship. I'll check up. Is it Mr. Sanjay Mishra? Sanjay Kumar Mishra was doing
Yes,
the
yes, correct.
I'll check up from him. I'll check up from him, Your Lordship.
Correct. What were you saying, sir? You filed a miscase for what?
Yes, miscase for payment under section 17B, man.
Oh.
That they have abruptly stopped.
What is your age now? How old are you, sir?
Must be around 70, Your Lordship.
Sir, just leave the question of law open, sir, Mr. Mishra. What is the point? Now you send it back to the labor code. Is 70 years old.
No,
Leave the questions of law open.
No. I'll help Your Lordship to answer this because Your Lordship. What is happening, Your Lordship?
There are some cases with passage of time, we should learn to gracefully give up so that there are other cases you can actually argue.
No,
Every case
Your
should
Lordship,
not be argued.
I'm never on the way of giving up the cases, Your Lordship. I'll always.
No, when the man is 70 years old, we send it back to the labor court. Another 10 years goes. What is the point?
I'll just check. Just Your Lordship, give me one moment. No, I'm sorry, sir. It is 56, 64, 65, Your Lordship. Not 70, 64, 65.
You should know, sir. What is your client's age?
60, you are
Mr. Bose.
63.
63.
63 in the 2015.
So he's 70 years old, sir. He's 70 years old now.
And in the 2015, he has filed that abruptly they have stopped.
And there is a stay here?
Yes, ma'am. Subject to compliance to section 17.
So nothing, because of his stay here and only 17B, he got nothing, sir. Only 17B.
63 years, he has filed, Your Lordship, the affidavit.
So no reinstatement, give me back wages.
Your Lordship.
Only back
Your
wages
Lordship,
will get
it's a case of
reinstatement
bank employee
now.
involved. No, the whole thing is that Your Lordship may kindly have a look at, then Your Lordship, I may just place the fact, Your Lordship. Your Lordship, kindly have a look at the
Possibly, Mr. voice is not audible.
Oh, am I audible, my lord?
Yes, you are.
Page 48, Your Lordship.
All right.
Page 48. Annexure 4, Your Lordship. This is an order of the tribunal, Your Lordship.
Right.
Your Lordship, subpara 3, 7 lines from the bottom, Your Lordship. In view of the above, it is ordered that the issue number 2, let issue number 2 be taken up as a preliminary issue, but insofar as the issue number 1 is concerned, the parties are directed to make their further submission supported by case laws as to whether the same can be taken as preliminary issue or not. Then you see the next page. Your Lordship, middle of the cases on perusal of the same, it is found that the Honorable Supreme Court have no doubt observed in these rulings to avoid hearing of an issue of preliminarily if the same is likely to delay the proceeding in resulting harassment to a party, but there is nothing mandatory in these rulings prohibiting hearing a preliminary issue at the first instance. From the impugn order, it appears the same has been passed after hearing both parties extensively. So on, so on, sir. Your Lordship, thus, Your Lordship, this issue number 2 was decided to be taken up at the first instance, Your Lordship. At this stage, Your Lordship may come to the issues which are at page 74. Page 74 of the award, Your Lordship. Internal page 6. Your Lordship gets it, page 74.
Yes.
First is whether the reference is maintainable. 2, whether the domestic inquiry conducted against the disputant was fair and proper. 3, whether the discharge of delinquent was assigned with special assistant duty from service by order dated 11/6/1999 is legal and justified. 4, whether the action of the management of Indian Overseas Bank by not clearing timely B. Ramesh Chandra's TA claims so and so and so is legal and justified. 5, if not, to what relief the workman is entitled. Now, Your Lordship finds just before the issues, on the basis of the pleadings of the parties, the following issues were framed, but out of these, issue number 2 was taken up at preliminary issue to be decided at the first instance. Then, if I finds the findings he has given, Your Lordship, my lord, the award on preliminary issue number 2, Your Lordship, that is the heading. Because evidence was laid on preliminary issue number 2 only, not on the other issues. That is my predicament, my lord.
No,
I
no,
am
no.
on the
But the
sixth
finding
man.
is in paras 13 and 14.
Yes, yes, yes.
And the finding is against you.
Findings on 13 and 14 your lordship relates to issue number 2.
No, no, no. 13 and 14 is on the fairness of the domestic inquiry.
Yes,
Page
yes,
83.
issue number 2 your lordship. That is issue number 2.
Correct. So
Yes,
there is
that
a
is
finding
issue
on
number-
that.
Yes.
Huh.
So 14 your lordship. After going through the above settlement, where the settlement is there, I don't know, your lordship, but it is gathered that in cases of charges of minor negligence, it is open to the disciplinary authority not to resort to start a departmental proceeding against the employee concerned. He can punish such employee without a regular inquiry being conducted, but in case of a major negligence warranting major punishment, an inquiry is to be held by appointing inquiry officer. Keeping in view the above provisions, the disciplinary authority under agreement 17.14 have given the discretion either to conduct the inquiry himself or appoint another officer as the inquiring officer for the purpose of conducting such inquiry. This provision does not mean that the disciplinary authority can conduct himself as an inquiring officer in cases where the delinquent is likely to get major punishment. But as I find from the instant case, the disciplinary authority himself has acted as the inquiry officer, all suggesting that the management was biased towards the delinquent workman.
So once the inquiry is held to be unfair, that's the end of the matter, sir.
No, my lords. There, your lordship comes in the Lakshmi Damama decision and Divyan Pandit decision, your lordship.
Yes.
Lakshmi Damama decision, your lordship has possibly dealt with in that your lordship's case, Mr. Mishra's
So
case.
the end of the day, what will happen? This has to go back.
My lords, because all the other issues have been precluded to
All
give
right.
any evidence.
So the net result is this has to go back to the labor code, correct?
It has to go back because there is no other
so
way. There is no other way.
there, since it's a 226 jurisdiction, can we not say the man is 70 years old and it doesn't seem to be advancing the cause of justice to now send him back when he's already superannuated?
If, of course, your lordship, if there is law which has been violated, your lordship.
Yeah, we'll leave that question open, sir. For some appropriate decisions, appropriate case, we'll leave it open.
Your lordship, may kindly have a look at the 2005 Supreme Court.
All
decision,
right. Give us a citation.
2005 AR SCW 5525. It's a very
SC 5525.
SCW Supreme Court Weekly.
SCW, okay.
SCW, your lordship. SCW
5525. All right. What's the name of the case, sir? Just give us the name. Cost it.
It is Divyansh Pandit. Divyansh Pandit versus management of NCC BM.
All right.
It's a very short judgment, your lordship. If you let me permits me, then I can just read out. It's a very short.
All right.
The appellant before us was an employee of the respondent council. Pursuant to an inquiry held, his services were terminated in 1987. The labor code before which a reference was made challenging the termination framed 4 issues for determination on the basis of the pleading of the parties. These 4 issues were: 1, whether the management is not an industry within the meaning of section 2J of the ID Act. 2, whether the Delhi administration is not the appropriate government as alleged in preliminary objection number 2. 3, whether the petitioner is a workman within the meaning of section 2S of the ID Act. 4, whether the domestic inquiry held by the management is improper and invalid, and whether the finding is perverse. The labor court decided issue number 4. According to the award, the respondent had given up all other issues. By the award, it was found that the inquiry was improperly held and that the conclusion reached by the inquiry officer was perverse. The order of termination was accordingly set aside and the appellant was directed to be reinstated with continuity of service and full back wages. We may note at this stage that in the concluding portion of the award, the labor court has noted that there is no request till today of the management to lead evidence in support of the charges and to prove the same. The labor court, despite holding that the inquiry conducted by the management was non-est in the eye of law, did not also consider the power which he undoubtedly has of allowing the management to lead additional evidence to establish the charges against the appellant. Be that as it may, immediately after the award was passed, an application was made by the respondent for review of the award. In the application, the employer stated: 1, that it had not forgone the other issues, and 2, that an opportunity should be granted to the management to establish its case. The review application was dismissed by the labor court, rejecting the first submission. However, the labor court did not apply its mind to the prayer of the management that it should have been granted an opportunity of leading evidence. The respondent filed a writ petition before the High Court challenging the award of the Labour Court. The writ petition was allowed and the award was set aside. The High Court was of the view that the Labour Court should adjudicate all the issues afresh. The matter was accordingly remanded back to the Labour Court for deciding of all the issues afresh. This order was passed on 2/12/2002. When the matter came back on remand, the Labour Court refused to redetermine issue number 4. The respondent then made an application for clarification before the High Court, seeking clarification of the order dated 2/12/2002. By an order dated 3/3/2003, the High Court clarified the order dated 2/12/2002 and held that it had in fact directed all 4 issues to be redecided and also directed the Labour Court to give only one opportunity to the management to lead evidence on issue number 4. An appeal was preferred by the appellant before the High Court. The memorandum of appeal shows that although the challenge was made to the order dated 2/12/2002, in substance, the grievance of the appellant was directed to the clarification issued on 3/3/2003. In fact, the division bench proceeded on the basis that the challenge was to the order of clarification dated 3/3/2003 and dismissed the appeal. The appellant has challenged this decision of the High Court before us. We are of the view that the order of the High Court dated 2/12/2002 as clarified on 3/3/2003 does not need any interference. It is true, no doubt, that the respondent may not have any prayer for additional evidence in its written statement, but as held by this court in Karnataka Road Transport Corporation versus Lakshmi Devamma, this did not place a fetter on the powers of the court-oblique tribunal to require or forbid the parties to lead additional evidence, including production of document at any stage of the proceedings, before they are concluded. Once the Labour Court came to the finding that the inquiry was honest, the facts of the case warranted that the Labour Court should have given one opportunity to the respondent to establish the charges before passing an award in favor of the workman. The appeal is accordingly dismissed and the matter is remanded back to the Labour Court for redecision as directed by the order dated.
All right. In that case, we don't know whether the person had already superannuated, correct? By the time the Supreme Court decided this case,
I cannot assist you in this matter.
That's what.
But here termination was in 1987.
Here, sir, we leave the question of law open because the person has already attained 70 years of age. We do not consider it to be in the interest of justice to remand it to the Labour Court. All right.
But only thing is that, my lord, I have not been allowed to give any evidence with regard to the 3 issues, your lordship.
All right.
On which the award has been passed, your lordship.
Okay, sir. Okay. Right.
That your lordship may kindly indicate.
All right. Disposed of. Right. We'll pass the detailed order.
List item 25.
Only one thing. My mistress is pending.
So that's also disposed of, sir. Now you go before the Labour Court for enforcement.
List item 25.
There are 3 analogous rates, my lord. There are 3 analogous rates, my lord. One of them, revenue has filed a response. The other 2, they have not filed a response till yet. And this pertains to, my lord, a contractor who does raising contract for various mines, my lord.
How long will this take, sir?
My lord?
How long will this case take?
Little long.
So we'll just keep it at the end of the board, sir.
In the board or, my lord?
End of the board. We'll take it at the end of the board, sir.
Within, I have some personal difficulty after lunch, my lord. Can it take up any other date, my lord?
All right.
And if my learned friend wants to file a response also, he can file a response within 1 week.
All right. Which case have you to file a response?
Second and third, my lord.
All right. Counter affidavit in 5663 of 2019 be filed within 4 weeks. Rejoined to the next. List on 14th July. All right.
We can list item 26.
There's an interim order, my lord.
All right. Interim order to cut.
Item 26.
Deep look.
We can list item number 26.
May I please, my lord? Lord, the writ petition is directed against the order of the Orissa Administrative Tribunal, Lord, rejecting the prayer of the petitioner, my lord, for appointment to the post of treasurer, my lord. The claim of the Lord petitioners was based on Lord circulars of the central government Lord, that 50% of the vacancies, Lord, the trained apprentice should be observed in 50% of the direct recruitment vacancies. Lord, these two petitioners, they have received, Lord, training as apprentice, my Lord. And my Lord, they have been denied, my Lord. Those two posts, Lord, coming to the facts of the case, my Lord, 7 posts are advertised, my Lord, for the post of treasurer, my Lord. My Lord, out of that 4 posts are made for the Lord unreserved category, and 2 posts for scheduled caste and 1 post for scheduled tribe. Out of the claim of the petitioners is that, Lord, out of these 4 posts, these 2 petitioners who were the only apprentices, Lord, they should have been observed against the 2 posts, my Lord. And my Lord, there are 25 persons who have, my Lord, called for the interview. Lord, in the interview, my Lord, Lord, to OP number 4 and 5 were appointed, and these petitioners have not been given. Lord, the Lordship may kindly come to the order of the tribunal. Lord, at page 18.
Yes.
No, sorry, my Lord.
It's
Lordship may
14
kindly come to page
A to L.
20.
You've put some 14A, 14B, 14C.
Lord,
the way you've numbered.
No, page 22, page 20.
There are 2 page numbers. The internal page, you've put some 14 A, B, C.
Lord, judgment internal, page 7.
All right.
Lord, page 20. We have had learned counsel for the parties on the reliefs of the applicants have prayed for in the way and have perused the materials on record. It is undisputed fact that it is undisputed that the applicant appeared at both the selection test in 1991-92 and in the merit list annexed sheet to the counter, they have been placed at serial number 14 and 19 respectively. So they have not been, so they were not considered for appointment. Further, by notification of 1992, 5 vacancies, applicants also have been called to participate in the interview. But they have claimed that their cases for appointment will be considered basing on the instructions of the Government of India, Ministry of Labour and Employment, communicated to the state of Orissa and to all concerned, including the principals of the ITI of the state. They have also relied on the decisions of the Honorable Supreme Court, cited supra, and have prayed that they should be given appointment as treasurers as per instruction of Government of India and as per the decision of the Supreme Court. The state respondents, have controverted such submission of the learned counsel for the applicant. The stand taken by the state respondent is that the recruitment to the post of treasurer is governed by provisions of the Service Rules 1990, which has been made by the governor in exercise of power conferred by proviso to Article 309 of the Constitution of India. So, since the applicants could not be successful,
you cannot avoid a selection process.
No, I have, my Lord, I have.
You are saying that merely because I completed the course, I should straight away get appointment.
My Lord, your Lordship, in that, my Lord, your Lordship may kindly see Annexure 2. In this context, my Lord, Annexure 2, page 26, my Lord.
Yes.
Annexure 2, 3 and 4.
So there's a judgment of the Supreme Court,
Lord.
para 8.
Para.
Internal page 10, para 8.
My Lord. Para 8, my Lord. Honorable Supreme Court in the case of Raja so-and-so, reported in so-and-so, have laid down clear criteria as to the regular appointment of apprentices governed under Apprentice Act 1961. Principles laid down are as follows. Other things being equal, a trained apprentice should be given preference over direct recruits. Lord, I am coming under this.
You can't read it in isolation, sir.
Thereafter, my Lord, for this, a trainee would not be required to get his name sponsored by the employment exchange. The decision of the so-and-so would permit this. My Lord, my name was sponsored by the employment exchange. If the age bar would come in the way of the trainee, the same should be relaxed in accordance with what is stated in this regard, if any, in the concerned service rule. If the service rules be silent on this aspect, relaxation to the extent of the period for which the apprentices has undergone training would be given. My lord, I was within this group. The concerned training institute would maintain a list of persons trained year-wise, and persons trained earlier would be treated senior to the persons trained later. In between the trained apprentices, the preference should be given to those who are senior. My lord.
Come to para 9.
The Honorable Supreme Court.
Come to para 9.
My lord, pardon, my lord.
Kindly come to para 9.
Para 9. From the principles laid down by the Honorable Supreme Court, it is abundantly clear that applicants have to participate in the selection process as per the Service Rules 1990, cited supra, for appointment as tracer. They are entitled to relaxation to the extent mentioned by Honorable Supreme Court at the foregoing paragraph 8. As per the principle laid down by at serial 1 above, preference to be given to the trained apprentices over direct recruits. The said preference can be given to the applicant over direct recruits who secured the same marks as the applicants in the selection process. In the present case, many candidates secured more marks than the applicant, and in that event, the more meritorious candidates have been considered for appointment.
What is wrong?
My lord,
What is wrong with this judgment?
Here the tribunal missed the point. My lord, my submission is, my lord, if there are more apprentices, my lord, seniors will be given preference. 25 persons were called, my lord. Only these 2 persons were the who received apprentice. My lord. Therefore, my lord, tribunal has given a total go by to the circulars, my lord. To the circulars, my lord, of the Annex of 2, 3, and 4. My lord, whole question is whether, my lord, tribunal has said whether the rule will operate. My lord, tribunal has said that this circulars, these executive instructions cannot supplant the rules. My lord, my submission is it is only supplementing, my lord. Law is well settled in Shantaram Sharma case, my lord. The executive instruction can supplement, my lord. It cannot supplant the rules. So, my lord, the anxiety of the government, your lordship may kindly see Annex 2 at page 26. My lord, at relevant page at page 27. In accordance with the suggestion of the central government, my lord, first paragraph I am playing. The undersigned is directed to say the matter of employment apprentices under the Apprentice Act 1961 against regular vacancies in the establishments has been under active consideration of this ministry since some time, and the same was considered in the Central Apprenticeship Council in its meeting held on 6/7/1982, wherein it was recommended that pending legislative measures, some % of total vacancies arising in every industry should be diverted.
You don't have to read the whole thing. Merely because there's a percentage reserve doesn't mean you automatically get it.
No, my lord.
Yes.
Whole question is,
yes,
my lord, next paragraph, my lord. Your lordship, next. In accordance with the suggestion of the Central Council, the matter was further considered in depth by a subcommittee.
Vacancies 50% are reserved for you.
No,
but in that 50%, there has to be some selection, sir.
Blood selection was made, blood.
Yes.
Application, blood names were sponsored.
All right.
25 persons were invited, my lord.
Okay.
My lord, we were only the 2 apprentices.
All right.
My lord, out of 4,
right.
if 2 posts are, my lord, are to be filled up by the apprentices, my lord, we are the 2 persons.
Right.
Since 50% of vacancies
right.
are to be filled up, my lord,
right.
there are only 4 posts, and
right.
50% would come to 2.
All right.
That is why, my lord, my claim is based on this circulars, my lord.
All right. All right. You see,
my lord, that was subsequently, my lord, your lordship may kindly say another state government, my lord. State government at the last paragraph, your lordship may see page 31. What is the anxiety of the state government? My lord, last few lines from the bottom. It appears from the ATS returns received from you for the period ending September 83 that not a single apprentice has been appointed against 50% of the direct vacancies of any establishment in your zone during the period 1984-1483 to 39-3-83. It is therefore not known as to whether the establishments in your zone are following the aforesaid instructions compulsorily. I would therefore request you to please follow up the matter by frequent inspection of the establishments and report the result to this office for further review and follow-up action. They are attached to your zone may also please be advised to change the matter in course of inspection of the establishment. State government is also keen that the apprentices should be absorbed, my lord. Here, my lord, they missed the point. My lord, those authorities, my lord, they did absorb the apprentices. My lord, the tribunal also missed this point. My submission is, my lord, as per this circular of the central government, Lord, these two persons should have been absorbed in the post of apprentices. Lord, they have not been given. Open number 4 and 5 are given the appointment. But this is my case.
Challenge in the present petition is to an order dated 14 January 2008, passed by the Odisha Administrative Tribunal, Cuttack Bench, Cuttack, bracket OAT, in OA number 134 of 1992. By the said order, the OAT rejected the contention of the two petitioners. They should have been appointed to the post of tracers on the basis of a 50% quota provided in terms of a letter dated 14th June 1983 of the Ministry of Labor, of the Regional Directorate of Apprenticeship Training, Ministry of Labor, Government of India. Paragraph. There were apparently 4 vacancies on offer for the post of tracer. According to the petitioners, since they had successfully completed the apprentice training, they should automatically have got 50% of those vacancies, that is 2 posts, as they were the only 2 apprentices in the fray. Paragraph. The tribunal has, while rejecting the above plea, referred to the decision of the Supreme Court in UP Raji Vidyut Parishad Apprentice Welfare Association versus State of Uttar Pradesh, AIR 2000 SC 2621, which lays down the criteria for regular appointment of apprentices governed with the Apprenticeship Act 1961. Paragraph. As correctly observed by the OAT, the Supreme Court has in the above decision emphasized that the service regulations of the concerned institution will be followed, except that the trainees would not be required to appear in any written examination. Full stop. In other words, the trainees would have to undergo some form of selection for appointment as tracers. Paragraph. On facts in the present case, the OAT has found that many candidates had secured far more marks than the present applicants, and the more meritorious candidates have been considered for appointment. Paragraph. The petitioners could not have avoided undergoing a selection process, notwithstanding that they might have qualified in the apprenticeship course. Stop. The court is not persuaded that the OAT has committed any legal error in coming to the aforementioned conclusion. There is no merit in this present petition and is dismissed as such.
Lord, that EP decision is also there, my lord. Supreme Court 2000, Supreme Court 2621, my lord, which has been quoted, my lord. Which say, my lord, other things being equal, the trained apprentice should be given preference.
Wiki list item 27.
None appears dismissal of.
Wiki list item 28.
In this case, the petitioner has availed a tractor loan manner. The tractor loan is entitled for subsidy as per government, as per central government scheme manner. That is disallowed by the central court bench, so I have come to the central court manner. The scheme is under Annex 4 manner. Also in the counter, the NABAR also admitted the same manner. That the tractor loan is availed, is entitled for subsidy manner. But the subsidy has not been allowed. They are saying that the bank was saying that this is the finance under SRTO scheme. So this is not under the loan scheme. So this is the dispute between the bank and myself.
I have filed my counter affidavit. Annexure 4, he is seeking a benefit under Annexure 4. That Annexure 4 is waiver of agriculture loan and reduction of loan under a particular scheme that is prevailed in the year 2008. That scheme was for the year 2008 and 2009, Lord. He actually availed a tractor loan. That was not for agricultural purpose. This scheme says those who are coming under the definition of agriculture, those who are coming under the, what is agriculture loan? what benefits to whom it will be extended. If your lordship see, this is in Odia, my lord, my Justice Patnaik, I can explain it in English also. 3, column 3, your lordship kindly turn to annexure 4, page 29. That is 3.1. It says कृषि उद्देश्य रे कृषक मानकु प्रत्यक्ष भाव प्रदान करा जायथिबा स्वल्प मियादी उत्पादन ऋण एवं निवेश ऋण को प्रत्यक्ष कृषि ऋण कुआ जाय थाय. It means the definition of agricultural loan. It says agricultural loan means short-term production loan and investment loans provided directly to farmers for agriculture purpose only.
Why is tractor not an agriculture purpose?
Your lordship may kindly see that sanction loan, sanction which have sanctioned annexure 1. Annexure 1 is the page 11. It is a term loan. We are to inform you that at page 11, annexure 1. We are to inform you that a term loan of rupees 2,97,000 sanctioned in your favor for the purpose of purchase of Mahindra tractor with trailer subject to the following terms and conditions. Condition number 3. The vehicle should be registered and used as public transport carrier purpose, my lord. This tractor is especially used for the public transport carrier purpose, not for the agricultural purpose. If the scheme you lordship see, the 3.5, 6 and 7, it defines the categories of farmers. There are 3 categories of farmers. One is marginal farmer, another is small farmers, and other one is other category farmers. So marginal farmer, it is having within 2.5 acres of land. It is stated in 3.5, and 3.6 is small category of farmers. They are having 5 acres of land. And those other categories, they are having exceeds more than 5 acres of land. And this petitioner has mortgaged his landed property more than 5 acres and took the term loan from the bank, my lord. And as for this scheme, my lord, it says if your lordship turn to, he can avail. We have given the notice under OTS. If your lordship see next page, column 5, waiver of loan. It says waiver of loan to those who can be loan can be waived for those persons, those who are marginal and small farmers. For other category of farmers, there is reductions. Reduction means OTS, my lord. We have issued a notice to consider him under the OTS scheme.
All right. Yes, sir. What do you say?
My lord, annexed to 6 under challenge.
My lord, only the tractor used for the agriculture purpose in the fields of agriculture only, my lord. It is not public purpose for transfer.
No, it says that. He's reading that.
Well, that is mistake of that bank, my lord.
What is that mistake? What is this? How can you say now the bank has made a mistake? We can't go beyond all that, sir. So it appears that the loan borrowed by the petitioner was for a tractor, but the tractor was meant to be used for transportation purposes and not agricultural purposes. So as a result, the petitioner could not avail of the facility of waiver of the agricultural loan, as it was not for a purely agricultural purpose. The second difficulty as far as the petitioner is concerned is that he is neither a small farmer nor a marginal farmer, but falls under the category of other, single quotes, other farmers, unquote, that is having more than 5 acres of land. On both these counts, therefore, the petitioner would be entitled only to avail of the one-time settlement scheme and not a complete waiver. Consequently, the reliefs prayed for in the present petition cannot be granted. The petition is dismissed.
List item number 29. Item number 29.
Lord, item number 29, I am appearing for the petitioners.
All right.
Lord, here a sale of a property that is a hotel has been under challenge before your lordship. Your lordship had granted interim order of status quo. Lord, here what has happened, Lord, the loan was taken, Lord, for the purpose of the hotel. The hotel, without notice, they had taken over possession under section 29 and then thereafter went for sale and sold it to opposite party number 4. A property worth about 2 crores has been sold at 27 lakhs, and that too.
What was the amount due from you, sir? What was the amount due from you?
No, there is nothing due. There is nothing due. because they sold the hotel. They sold the hotel.
Before they sold the hotel, did you owe the bank and OSFC anything, or you owed them nothing?
Yes.
What
Yes.
was the amount that you owed the OSFC?
That the OSFC can
Please, you
highlight
should
to
know,
Lord,
sir.
because how much was the because
You should know.
yes, Lord. Lord, what happened? They appropriated the amount and
Sir, you
adjusted.
tell us what is
and
the
thereafter
amount. You tell us what was the amount.
demanded rupees 33 lakhs.
With interest
And
or without interest?
settled for an OTS amount of no. That also is not there. The amount the due after adjusting was 32 lakhs, and that there is no dispute about that. It is now the property which has been sold. I am before your lordship.
Are you prepared to pay 2 crores?
The dues are not.
Are you prepared to pay off the buyer of your property?
Lord, he has purchased it.
Today's market rate, you pay the buyer, you'll get back the property.
Lord, he has purchased it for 27 lakhs.
No. Today, what is
He
the
has purchased
value of
it.
the property? Today, what is the value?
Lord, one aspect, I know, Lord, I know my limitations, Lord, what your lordship is. Your lordship may see the order dated 9/11/21, passed by your lordship. 9/11. In this case, your lordship had noted that there is a question of negotiation which is at final stage. This negotiation, Lord, I have given a letter today to your lordship's, Lord, for your lordship's reference. Lord, the Industries Department has now said, your lordship may kindly see that letter, 27/10/21. 27/10/21. In inviting reference to the subject cited above, I am directed to forward here with the copy of representation so-and-so relating to WPC so-and-so. This presented petition. Previously, a representation has already been forwarded.
Who's in possession, sir? Who's in possession? Mr. Pangari,
Possession, he is in possession.
You are the purchaser. Whom are you appearing for, sir?
Opposite of the 4 minutes.
You are the purchaser.
Purchaser.
You are in possession.
I'm in possession since 94 minutes.
94?
Since 94.
I see.
Sale was conducted on 23 March 1994.
Very brave of
Possession was handed over to me on 31st March 94.
So the 30th, soon we'll celebrate 30th year of your litigation.
Lord, may I pray one thing,
refer
Lord?
to
May I
all
pray one
judgments of
thing?
the Supreme Court in the similar cases, my lord, whose sale has been confirmed. Even 1.5 years, 2 years after people have come to the court have not entertained the
Lord, may I pray, Lord, may I pray something, Lord? As per this letter, they have advised me to approach the MSME department.
Vacate all the interim orders, you approach whomever you want to. All right.
Lord, your lordship will kindly indicate that.
To withdraw this petition with liberty to approach the Industries Department, Government of Orissa, in accordance with law.
No, Lord, not Industries Department. Industries Department has now written to us that you approach the MSME department.
All right, MSME department in accordance
Your
with
lordship
law.
may kindly, your lordship may kindly
Disposal is
refer to
withdrawn
that.
with liberty is paid for, the interim order stands vacated. All right, sir. Contempt case is closed. All right.
Weekly list item number 30.
None appears dismissed now.
Weekly list item number 31.
None appears dismissed now.
Weekly list item number 32.
None appears dismissed now.
Weekly list item number 33.
Lord, in this matter, this Kendrapada municipality petitioner has challenged the order of labor court in rejecting the petition on the question of maintainability of a petition filed by the opposite parties under section 33C2 of the Industrial Dispute Act. Now, coming to the background facts, there were actually 25 numbers of applicants. They have filed the matter.
And then during the proceeding, they have asked for computation and determination of alleged arrear wages. This alleged arrear wages came out of a letter issued by the department that they have to pay certain amount of wages per month. But during the course of hearing, proceeding before the Labor Court, 19 of the number of applicants, they have withdrawn their claims. And whatever the present in the writ petition opposite parties, out of them, 6 out of them, opposite party number 3 and 5 petitions for withdrawal of their claim during pendency of the writ petition, but that was not allowed by the Labor Court, being on the ground that the interim order is prevailing. So that is still pending. I filed all those documents also as annexures with an affidavit. And opposite party number 6, one Sri Vishnu Sarana Behra, in the meanwhile, he has expired also.
Why do you want to pursue this then, sir? There's just three of them left then. Why do you want to pursue this?
No, that's what, there is no.
No need to pursue it, sir. So many people are dying or withdrawing. Nothing's going to happen. You say the present petition has been filed by the municipality, questioning an order dated 1st June 2009, passed by the Labour Court Bhubaneswar, in this case number 49 of 2001, whereby the Labour Court rejected the preliminary objection raised by the present petitioner regarding maintainability of the aforementioned miscase number 49 of 2001 by the opposite party workmen under section 33C2.
Yeah, under section 33C2
of the Industrial Disputes Act 1947, paragraph. While issuing notice in the present petition on 25th August 2009, the impugned order was, there was stay of further proceedings in ID miscase number 49 of 2009 pending for the Labour Court. Paragraph. When the present petition was filed, there were 7 opposite parties. Full stop. During the presidency of the present petition, opposite party number 5.
Opposite party number 3 and 5.
3 and 5 have withdrawn their claims. Then one expired.
One expired. Opposite party number 6.
Opposite party number 6 has expired. Opposite parties 2 and who wanted to withdraw?
2, 4 and 7, they have worked for few days and they have left the service for last more than 20 years. They're not in employment.
All right. Opposite parties 2, 4 and 7 have left service and have not been in employment. Full stop. All of this has been stated in an affidavit dated 7th March 2021 of the present petitioner. Full stop. In view of the above facts, there's no need to continue to entertain the present petition as the main industrial dispute case itself may not proceed. The petition is accordingly disposed of.
Weekly list item 34.
My lord, 34, my lord, sole petitioner has died, my lord, in the meantime. So I have contacted his son on Sunday. So he will come and file an application.
What is the matter about, sir? What is the matter about?
My lord, the matter is about the land of the petitioner which was continuing in the name of his grandfather, then father, then the present petitioner has been occupied by the Gram Panchayat without initiation of any land acquisition proceeding by the government or any payment of any compensation. That is the case, my lord. Lord, I will convince my lord that this writ petition is maintainable and the civil remedy is not to be efficacious remedy, but I pray that some time may be granted to file the application for substitution.
1 minute. $34, is it?
Right.
Who's for the other side?
I'm appearing for this.
What is this about?
This is about, your Lordship may kindly see, the petitioner is claiming right title interest on the basis of an order passed by the Tahsildar and which was reversed by the Board of Revenue in the case under section 38B of the OE Act. And actually, this Bebanda was the case number 232 of 1988. By virtue of this the order passed by this in this case, he is claiming that I am the owner, and actually the Gram Panchayat office of that particular GP is located over this land. It is the government land, and this is the stand. Once it was allowed without hearing the opposite party, state authority, and the matter went up to the
Supreme Court has come back.
Supreme Court has come back. If my learned friend will argue, I will submit that.
No, he says he has to substitute. When did he die, sir? When did the petitioner die?
For 1 week time may be granted.
So when did the petitioner die?
Lord, I have not got the exact information. His son will come and inform me, and I will file. If it is delayed too much, then your Lordship may pass appropriate order.
Counsel, the petitioner states that he has been informed that the petition has expired and needs to take steps for bringing the petitioner's LRs on record. 29th June.
Weekly item number 35.
The opposite case is covered by your honorable court judgment. Covered materials.
Covered matter.
Bona fide purchaser.
Yes, Lord.
Challenging the present petition is to an order dated 18th January 1985.
My lord, seems to be not covered by this judgment, that with my humble submission, because here the petitioner is not
himself.
Himself
it is against him only.
Yes, he's not a purchaser or something acquired himself. He has appeared before the
he has appeared,
and everything is this in
the
this
petitioner has not been heard by
that
the
is
notice that he issued, but not heard. No opportunity has been provided to be heard by.
If the notice is made sufficient and you did not appear.
No. In fact, you filed a show cause notice. A show cause. Come to page.
Yes, your Lordship. Annex 3, I have filed show cause. Annex 2.
Yeah.
Your Lordship, thereafter, several date has been made, and an assurance made that I should be provided an opportunity to be heard. No opportunity has been.
Right. As long as your show cause is issued, that's enough, sir. As long as show cause is issued, that is more
Yes,
than
so cause is already filed.
In a similar matter, your Lordship, kindly this honorable court order, your Lordship.
This is
No,
not.
no,
This
it's not
is about
similar.
third party.
It's
When
not
you're
similar.
not issued any notice
It's
whatsoever.
not similar. It's not covered.
Not the same case. It's not a similar case, sir.
Your Lordship, as your Lordship, as per the OJLS rules, your Lordship, where the salami is paid, as per the approved lease principle, the OJLS rules is not applicable to the aforesaid.
Just come to the reasoning, sir. Come to the reasoning.
Yes, sir.
Page 14.
Yes, sir.
He's not a landless person.
No.
Lordship, no counter has been filed by the state whether he is a landless.
You have
Still,
to, you
that
are,
is the fine.
you are assailing this order. You have to tell us what is wrong with the order.
Lordship, the petitioner, after paying the salami, he has acquired the land.
No, he has not acquired anything.
The petitioner was peaceful possession over the said land and is continuing
Mere
this.
possession is not enough, sir. You have to show how you get title to it.
Thereafter, they have provided that the notice should be issued for the
No,
hearing.
no. So the challenge in the present petition is to an order dated
Lordship, kindly have a glance to
18 January
page 4,
1985.
paragraph 8.
What is the reason for the delay in challenging the impugned order?
Your Lordship, kindly have to page 4, paragraph 8. In the aforesaid fact and circumstances, it is more relevant to mention here that all on a sudden on 21.
No. When you filed a reply to the show cause notice, how can you presume no order will be passed?
Your Lordship, when the petitioner taken step to correct the error in his favor in the settlement office, he came to know that the settlement
You
of
filed
his.
a reply to the show cause notice. After that, you can't simply presume nothing is going to happen in your case.
Your Lordship, after so cause a reply has been made without serving any further notice in reflecting the reason and ground.
Further notice is required. After you file the so it is your duty to pursue the case.
We have appeared and different dates have been made and with the assurance that opportunity should be made for hearing of the case.
All right. The challenge in the present petition is to an order dated 18 January 1985, passed by the Additional District Magistrate Bhubaneswar in lease revision case number 147 of 1983. By the impugned order in exercise of the suo motu powers under the OGLS Act, the ADM Bhubaneswar cancelled the lease in favor of the present petitioner. Out of Khata number 443, plot number 1215, area AC 0.100, is it?
Yes, sir. 100 decimal.
Mauza Ghatkia. Paragraph. The main plank of the submission of the counsel for the petitioner is that the impugned order has been passed without affording the petitioner an opportunity of being heard. As regards the delay in filing the present petition, it is sought to be explained that when the petitioner approached the ADM to get the ROR corrected, he was all of a sudden surprised ROR corrected on 21st 10/2009. He was surprised to know that the lease had been cancelled in the aforementioned case. According to the petitioner, he had not been served either with the order of cancellation or any notice for implementation of that order. Paragraph. Having heard learned counsel of the parties, the court finds that the impugned order refers to the fact that a show cause notice was issued to the petitioner in the revision case. And in fact, the petitioner submitted his reply on 17/12/1983. Also, therefore, this is not a case where no notice was issued to the petitioner. Paragraph. Having received the notice and having filed the reply, it was incumbent on the petitioner to have followed up the proceedings and ascertained the outcome thereof. Therefore, the court is not prepared to accept the explanation offered by the petitioner that he was not given sufficient opportunity and that he was somehow surprised on 21st October 2009 when he approached the settlement office for change of ROR about the above order. Consequently, the inordinate delay of nearly 35 years in challenging the impugned order is not satisfactorily explained. Paragraph. Apart from the issue of inordinate delay and laches in preferring the writ petition, the court on the merits also finds that no case was able to be made out by the petitioner on merits. Made out by the petitioner, full stop. Importantly, it was found by the ADM that the petitioner, no inquiry was conducted to ascertain if the petitioner was a landless person and no other profitable means of livelihood, in order to make him eligible for settlement of land in his favor. There was therefore a clear violation of section 3(3) of the OGLS Act paragraph. Consequently, the court finds no reason to interfere with the impugned order of the ADM. The petition is dismissed. The interim order stands completed.
Weekly list item 36.
But this matter also stands covered by a lordship's judgment and subsequent orders, my lords. This relates to cost establishment charges as per in exercise powers under Rule 34(2). May I just pass on that judgment and order of your lordship minutes for the subsequent and other periods of the same petitioner.
Oh, I see.
Petitioner is the same. The first one is your lordship's order following the judgment of this honorable court, which I have also given.
All right. Who's for the other side?
I am appealing for this. The same petitioner.
So it's covered
It is covered.
in view of the order dated 4 December 2019 in the petition civil 5628 of 2043 bracket Messrs. Umeri Distillery Private Limited, State of Orissa, and the order dated 23/11/2021 in the petition civil 16387 of 2011 bracket Messrs. Umeri Distillery Private Limited, State of Orissa, which pertains to the same assessee for the different years. The
Your lordship have said that the circular and
the circular dated 3rd January 1990 and the consequent demand notice
it is 6/3/2010, Annexure 3.
dated 6/3/2010 are hereby quashed. The petition is allowed no orders to pass.
The lordships have also directed for payment of this recovery already made. That's a paragraph.
Same line, just show this.
Paragraph 2 minutes. Paragraph 2.
The recovery if already made from the petitioner shall be refunded. The amount recovered from the already refunded from the petitioner will be refunded to it within 4 months from today, or will be adjusted in future transactions.
Greatly obliged.
All right.
Weekly item 37. Weekly list item 37.
None appears dismissed from opposition.
Weekly list item 38.
38, my lord, there is no instruction.
Answer the petitioner states he has no instructions. Dismissed.
Weekly list item 39.
May I please?
This is a
My senior is on his legs in the other court. One passover, please. My senior, Mr. Misra, is on the other court.
Whom are you for, sir?
Myself, P.K. Sharma.
You wait, sir. Let us see if he is making out a case. Yes, sir.
The employees under the BSNL are eligible having qualification eligible to appear for the junior Hindi translator post. And there is a recruitment rule I have annexed, Annexure 1. There is also notice. Nowhere therein it is mentioned he did not possess the qualification as per recruitment rules. Then Annexure 2, 17 March 2008, page 13. Page 13. It was mentioned for one time. I'll pay page 14 rather. Page 14. Page 14 top. Conducting another examination to fill up the post of junior Hindi translator through a limited internal competitive examination for internal candidates with the following education qualification as a special case. One, internal candidates possessing the educational qualification as prescribed under the column 9 of the recruitment rules, junior Hindi translator. Two, internal candidates possessing masters in bachelor or medium examination must have taken Hindi as one of the subjects at 10th level or above. Now, This is the special dispensation for one special regime. Now the petitioner files application.
Sir, what was the, he's a general candidate or a?
OBC.
So reserve candidates, the upper age was 50 years.
That is not in dispute.
One minute, sir.
He is within age.
Sir, you're not allowing, I find you people are not allowing me to ask a question.
Sorry.
So what I'm going to do is I'm not going to ask questions.
Sir.
I'm only going to ask Justice Patnaik to ask questions.
My lord.
The upper age limit is 50 for the OBC candidates. And so far as the petition is concerned, as on 2010, the age was 40. Now it will be 52.
Yes, in the meantime, he has got it. Then next examination. He has cleared. Because of academic qualification.
Survives. In 2011, again, in 2010, there was another advertisement.
So I'm asking you, what survives?
It survives, Your Lords. Your Lords may kindly have a glance to order dated 17/5/2011. Order number 11.
He has subsequently appeared and cleared it because of academic qualification.
This is that selection order of 2011.
Only get seniority from the earlier term.
This is the order. My lord.
So what? You've joined without prejudice to your rights and contentions now.
Right.
You have joined without prejudice to your rights and contentions.
In 2011.
So what is remains therefore?
So I should be given with retrospective effect in terms of the judgment of the learned cat. And with that protection, I joined.
So you will, sir, now that therefore you will now fight it tooth and nail, correct?
No, he is not eligible.
So fight it. Let us see now. All right, argue. Union of India's functioning will come to a grinding halt. It is given retrospective by 1 year. Very good.
2 years.
Wow.
2 years.
It will come to a phenomenally grinding halt. How are you wasting time on this kind of litigation, sir? Union of India, nice policy you have, non-litigation policy. But nothing, not even an inch you have to give. Because the whole government will come to a grinding halt.
Not that way, Lord. We have to fight.
You have to, sir. Fight tooth and nail. That's what I'm saying. Fight. Please
from
fight.
2002 to 2019, Supreme Court several times said the courts and tribunals are not entitled to seek for a equivalence.
Correct.
Only that is prescribed in the equitable rule or the arrangement. It is not there. Now,
as a Union of India, you should know which litigation you want to pursue, which you want to give up. You give up litigation which is worth 10,000 crores, 20,000 crores. One poor Hindi translator in BSNL who just wants retrospective promotion from 1 year, 2 years, you will fight tooth and nail.
Well, that will change the policy.
Good, very good. No, we really appreciate your spirit.
Well,
we really appreciate. Yes.
See, now my to turn page 20.
Yes.
Page 20.
Yes.
He has passed HSC in English, class 2 in English, class 3 in English. He did not have Hindi as one of the subjects, which was a compulsory description. He must have Hindi as one of the subjects in 10th level or above. He did not possess that. He says that after completing all these things, I have passed Rashtrabhasha Prachar Samiti, I have got some qualification of Hindi. You make that equivalent. That is not, there is no mention in the curriculum rule that Rashtrabhasha Prachar Samiti qualification will be allowed, nor in the arrangement. Now the tribunal says that no. Once you got qualification Rashtrabhasha Prachar Samiti, therefore you should be eligible. That is the thing.
What is which is the para number of the
tribunal order?
Yes.
You have 55. Hindi is one of the subject 10th level or above. admittedly applicant is having qualification of Hindi Abhigyan, which is recognized as the qualification equal intermediate. Qualification intermediate is above the qualification of 10th. On that basis, they are given by equivalence.
Sir,
he did not a Hindi.
1 minute, sir. We are not even interfering. Why are you?
Sorry.
We are already against him.
They filed an application for extension of time to implement the judgment. That is at Annexure Q.
Yes.
Maranasi. Supreme Court of 2002 till 2019 have given for judgments.
All right.
My lords.
Very good, sir.
Very good said that you cannot, courts is not entitled to enter into equivalence clause and allow it.
All right.
I have given the for judgment.
All right.
State of Rajasthan and Lata Arun.
Right.
Paragraph 10.
Right.
C. First judgment.
Right.
Shall I place, my lord?
No problem, sir. We'll refer to all of them.
No.
All
Then latest in 19, para 9, judgment of Maharashtra Public Service Commission,
Right.
Secretary Sandeep Chiram. Same, similar. That you cannot, court is not to say it is equivalent and give it.
All right.
Because the rule doesn't permit that.
Okay. Okay. Right. Challenged by the Union of India. The present petition is to an order dated 10th November 2009, passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, bracket C80, allowing OA number 152 of 2009 filed by the opposite party and directing the petitioner to treat the Hindi Abhigyan qualification of the petitioner as equivalent to the qualification of having passed Hindi in the intermediate grade and to permit him to apply for the selection for the post of Hindi translator in the BSNL. Junior Hindi translator in BSNL. Paragraph. While directing notice to issue in the present petition on 14th December 2010, the court directed that no coercive measure would be taken against the present petitioner. Paragraph. As it transpires in the subsequent selection, the petitioner is in fact qualified and by an order dated 17th May 2011, this court permitted him to join the post without prejudice to his rights in the writ petition. Consequently, in his appointment letter of 28th March 2011, where does this letter say that?
Subsequently, there was another order. They didn't release him to join in the post. Then again, after 5 months, they issued this. That was a selection. This is the final order.
Then you take off the last line.
He joined on 8/8.
Pursuant to the above order, the petitioner joined the post
on 8/8/2011.
On 8th August 2011. And is currently working as such. Paragraph. The only question that remains is whether the petitioner would be entitled to count his notionally treat his appointment as being from the date that the other successful candidates pursuant to the selection held in 2005.
May I intervene for a moment? Other candidates have been appointed. They have not been
Joined.
made parties to challenge their
Stop.
appointment.
Paragraph. Counsel for the petitioner relies on the decisions in State of Rajasthan versus Latarum, AR 2002 SC 2642, PM Lata versus State of Kerala 2003 SCC 541, Prakash Chandra Meena versus State of Rajasthan 2015 8 SCC 484, and Maharashtra Public Service Commission versus Sandeep Sriram, AR 2019 SC 2154, to urge that the task of equating two qualifications should be best left to the employer, and the tribunal on its own should not undertake such a task. Paragraph. The court finds that the CAT has in the impugned order not taken upon the task itself of equating the posts, but has only referred to the clarification furnished decision of the Government of India itself treating Hindi Abhigyana as equivalent to intermediate in Hindi. Full stop. If Abhigyana is recognized as a qualification for intermediate and it is above the qualification of 10th, there is no reason why the opposite party should not have been granted that benefit and be allowed to appear for the selection. Full stop. The court does not see any great prejudice being caused to the petitioner by the impugned order of the tribunal, particularly since the petitioner has anyway, the opposite party is anyway qualified in the subsequent selection. The court finds no reason to interfere with the impugned order of the CAT. The petition is dismissed. The interim order stands vacated.
Weekly list item 40.
No instruction, Your Lordship.
All right. Counsel petitioner states he has no instructions.
Weekly list item 41. Item 41.
None appears dismissed.
Weekly list item 42.
Madam, 41 item, appearance of Union of India may be noted.
All right.
Item 42.
None appears dismissed. No.
Weekly list item 43.
May I please, Your Lordship? This is a public interest litigation filed by a large number of tribals. Their claim is their land has been acquired since 1954 and they have received their compensation and other benefits. They have no grievance for that. But their tribal peoples, they worship the nature. their DT is called Sarna. From the acquired land, both the state government and the Raurkela steel plant allotted land for Gurudwar, Masjid, and some Hindu temples. But for these tribal peoples, no land has been allotted for their DT. After filing of this writ application, there was an inquiry conducted by the National Commission of Scheduled Tribe under Article 338A of the Constitution of India. And in respect of some of the Sarnas, this is a report submitted by him and directed both the Raurkela steel plant and the state government to allow some lands to them. And there is a specific order by the National Commission at page 2 of the brief of that order. Today morning I could get this order. I could not file for a properly duly constituted affidavit. But the first letter is by to the additional district magistrate by the general manager of RSP. And this, I will take your lordship to the second letter first, because this is the letter of the National Commission for Scheduled Tribe. Surrender of 6.30 acre land in Raurkela and its reservation for religious activities at Sarna Puja Sthal. I am directed to refer to this above subject and to say that during the visit of National Commission for Scheduled Tribes to Raurkela district Sundargarh and its meeting with the district administration and the Raurkela steel plant authorities, the commission had expressed its view to return the unused tribal land acquired by the government of Orissa during the establishment of Raurkela steel plant to the displaced scheduled tribe measuring 6.30 acre of religious purpose, that is Sarna Puja Sthal. This land is already under peaceful possession of the tribals and is being utilized by them as Sarna Puja Sthal. On earlier occasion also, this commission has strongly recommended for
What
this
is your
same.
reaction to this letter, sir, Mr. Monty?
My lord.
What is your response of the R&D?
No, today he has not served copy of.
No. Today morning itself,
Mr. Samal has handed over to the court copy of a letter dated 4 January 2019, written by the National Commission for Scheduled Tribes to the Secretary, Revenue and Disaster Management Department, Government of Odisha, requesting that urgent steps should be taken to return 6.30 acres of land acquired for the purposes of the Raurkela steel plant, and which is lying vacant and unused, back to the original owners of the community for its utilization as Sarna Puja Sthal. Mr. D.K. Monty, learned AGA, states that he needs to take instructions on the response, if any, on the response of the state government to the said letter at his request list on 29 June.
My lord,
29th.
weekly list item 44. Item number 44.
There was an order asking to file a reply.
Yes, my lord.
No reply has been filed. No lawyers appearing.
No.
There's an order asking
Counter is not filed.
DLSC to allot a lawyer.
No counter has been filed as I find from the.
The direction to you to file a counter.
Yes, my lord. Counter is ready, but it is not filed.
What have you said in your counter?
My lord.
Counter is ready, you said. What have you
Yes,
said?
it is there. I find the draft
No,
counter
what
is
have you
there.
said there?
Yes. It is stated that the petitioner were distributed ceiling surplus land and in Paramanpur village as per details given below. Thereafter, it is respectfully submitted that the consultation awards were issued on these beneficiaries by the then Tahsildar Rengali during the period when the notification under section so and so under the OCH Act had been notified. So the power of the Tahsildar to correct the awards without the prior permission from the Joint Commissioner is not permissible. As a result of the Commissioner Khatanov issued to the above beneficiary does not tally with the names of the recorded tenant. As per the consultation records available in the record room of Deputy Director Consultation Holding Sambalpur, as per the verification report of RI, the consultation awards stand recorded in the name of the following persons: Radhanath Mishra, Gopinath Vibhar, Sudarshan Pradhan, and further it is stated that plot numbers. These are all informations which are to be supplied with documentary evidence, I think.
When order dated. June 2012, this court had directed the government advocate to file a counter affidavit. Mr. Manthi states that the affidavit will be filed within 2 weeks. The High Court Legal Services Committee, the member secretary, Osla, is directed to ensure the presence of a lawyer on the next date. A copy of this order be sent to the secretary, OSLS, forthwith, compliance. This is on 4th May.
Weekly list item 45.
None appears.
My lord is fixing 4th May.
Weekly list item 46.
MC 11736, none appears, dismissal, non-prosecution.
Weekly list item 47.
MC 19164, none appears, dismissal, non-prosecution.
Weekly list item 48.
On behalf of GK Mr. No instruction from the petition.
All right, MC 2853. Counsel for the applicant states he has no instructions.
Okay. Weekly list item 49.
My lord, here, the second matter, you just say dismissal, non-prosecution.
Weekly list item 49.
My lord. Here, my lord, the state has filed a recall petition, my lord. Here, the item 49, a miscase for recall has been filed by the state government, my lord. Here, the original dispute was the challenge to a cancellation of promotion, my lord, which was disposed of with a direction for remand with an observation that notional promotion may be extended, my lord. Thereafter, my lord, the petitioner has filed a petition for modification of order that in that ordering portion, my lord, wrongly it has been stated that the petitioners were retired. His prayer was only limited to that. They are not retired, they are working, my lord. But while disposing of that miscase for modification by the petitioner, the order has been passed to give them all financial benefit from the date of promotion, my lord. If you, for your lordship's convenience, my lord, I have made 2 copies of this order, my lord. Your lordship may kindly peruse, my lord, the last but 1 page, my lord, which starts from para, the disposal order, that is important, my lord. The para 7 of the order, your lordship may kindly, last but 1 page, my lord.
No material has been produced.
My lord, last but 1 paragraph, internal page 3, my lord. The order which I have handed over, my lord, just now, my lord.
How does it start? No material has been produced.
No, my lord, it starts with at rupees 400 to 2600, my lord. This is the order, my lord. Para 6, my lord, it starts with, it appears that all these writ petitions are identical to OJC number 12250 of 1999, which was disposed of by this court by order dated such and such with following orders, my lord. Your Lordship, then kindly come to last portion. It is important, my lord. It is stated that the petitioner has already retired from service in the meantime. After superannuation, we therefore direct that the petitioner be given promotion to the post of headmaster of any taken over UPME school with effect from the date his immediate juniors were promoted, and such promotion shall be given only for the purpose of retirement benefit. The petitioners having not worked as headmaster, he is not entitled to any area differential salary. The period of service as headmaster as directed above shall be taken into consideration for the purpose of pension only, my lord. Thereafter, your lordship may see, my lord, para 7, no material has been produced before us to show that the aforesaid order of this court has been challenged anywhere. It is stated that all the writ petitioners have already retired. My lord, the petitioners subsequently filed a miscase for modification of this part. I will come to that, my lord. All the writ petitioners are similarly situated with writ petitioner in OJC number 12250 of 1999, and their case is squarely covered by order passed in this said writ petition, which I have read, my lord. Is not disputed by Lawrence Standing Council.
So recall is very different. Why did you not file a review?
My lord, at that
this
point
is not merely recall. Sir, what you're asking for is a complete
here
review.
what has happened, lordship may kindly appreciate. Here, if your lordship will go to the prayer of the petitioner, the modification petition filed by the petitioner, he has only prayed to substitute this retirement part to that he was working. Your lordship may kindly see the miscase, my lord, which was filed by the petitioner. Which was filed by the petition, that is miscase number 20865 of 2007, and the prayer portion, my lord. It is therefore prayed that this honorable court may graciously be pleased to allow this application and modify the order dated at the past in WPC number, thereby inserting the petitioner is now working as headmaster in such and such school in place of all the petitioners have already been retired from service. But your lordship may, if your lordship may see the third page of the order, my lord, which I have handed over, my lord, which was passed while disposing of this miscase, my lord. There, my lord, in the second paragraph, however, the present petitioner since continuing service, he has already been promoted. He is entitled to get all consequential service benefit from 8th October 1997. From 8th October, he was not holding the promotional post, my lord. And the original disposal order, my lord, it has been stated notional benefit may be extended.
All this, sir, this is not just a recall. Recall is a very innocuous word. Either you file a review,
my lord,
or you file a, don't resort to this IAS and all. File a proper review petition.
My lord, you lost me that liberty, my lord, authorized.
Counsel the petitioner seeks leave to withdraw this application with liberty to file other appropriate proceedings in accordance with law. Dismisses, withdraw, disposed of his withdrawn liberty straight.
Equal list item 50.
MC 16217, none appears. The application is dismissed for non-prosecution.
Weekly list, passed over matter, item number 11.
Yes, Mr. Ragada.
In this case, my lord, my associate initial, my lord, in the first hour pray for time, my
No,
lord,
no, no.
because my lord,
We knew you'll be free after lunch. That's
my lord, what happened, my
criminal
lord?
matters, we need
My lord, he's in bail.
experts to be there.
My lord, he's in bail, my lord. But one that might be given next to
Mr. Ragada, this matter is nothing for you. Come.
My lord, that
We'll help you. We'll help you. Come,
But
come.
in fact, my lord, looking the page number 4 of the paper book, my lord, I'm little bit confused, my lord. The judgment delivered
We'll try and alleviate
my lord is not there at Sambalpur, my lord. I am
Come.
little bit confused.
What is this eyewitness case or?
My lord, there are PW 3 and 2, 3 and 4. They claim that the
matter item number 15.
May it please your lordship.
Yes, yes.
PC, and he was was sentenced to undergo rigorous imprisonment for life and a fine of rupees 5,000 and default to undergo 6 months of imprisonment. My lord, the present case attracts the provisions of section 84 of the Indian Penal Code, which provides that the nothing is an offense which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or what he was doing what is either wrong or contrary to law. So, my lord, this present case fulfills the requirements of the insanity. The deceased was the mother of the appellant. And the prosecution story is that on 12/4/2005, when the appellant was about to go to a village, Gidamal, and the deceased asked him not to go anywhere because it was a Chaitra Amavasya. But hearing this, the appellant got furious and assaulted his mother with her walking stick and pelted stone on her and PW2. PW2 is the father of the appellant. So, my lords, my humble submission is that the appellant was suffering from mental illness, and it is well established by the deposition of PW1, 2, and 3, who are the brother, father, and wife of the appellant. And he was getting regular fits, my lord, since childhood. Your lordship may kindly see page 24. Is the deposition of PW1.
Where is he on bail now, or?
No, my lord, no bail. He is in custody since the day of arrest. Since 2000, from the date of occurrence, he is in custody.
Which is when?
Since 13/4/2005.
So he's completed 16 years. 16 and a half years.
Approx 13 years. 17.
Just read para 8 of the judgment.
My lord.
Page 48.
May I read? My lord. The learned advocate of the accused has made an effort to bring the offense under the purview of section 84 of the IPC on the plea that the accused is insane and was not capable of knowing the nature of his acts. He relied upon the evidence of his father, PW2, during cross-examination that the accused in his childhood was getting regular fits and when irritated was lifting and throwing his own child. The accused at times was losing control over himself. He could not continue the treatment of the accused for his mental condition due to his poverty. The evidence of PW3 that from the date of her marriage with the accused, she found her behaving like a madman is also pressed into service to prove the insanity of the accused. The crucial point of time at which unsoundness of mind should be established is the time when the crime is actually committed. The mere fact that on former occasions the accused behaved like a mentally deficient person or had suffered from the derangement of mind is per se insufficient to bring his case within the general exceptions. In order to ascertain whether the accused was insane at the time of commission of offense, the state of his mind immediately preceding and subsequent to the commission of the offense is relevant. The accused took his bath and told that he was proceeding to village Gidamal. When the deceased mother objected her, he got annoyed, saying that the old woman was always raising objections and assaulted her by her walking stick and also with stone on her head, and went away and sat under a tree, which is apparent from the evidence of his wife, PW3, which the accused also admitted. The accused clearly understood the questions put to him during his examination and gave clear-cut answers. From the conduct of the accused preceding and subsequent, it can never be held that he was insane or he was of unsound mind and was incapable of knowing the nature of his act. He was compos mentis while assaulting on the head of the deceased.
See, what are the injuries on the deceased?
My lord,
PW 6 page 35 loss.
Page 35, is it?
Page 35.
All right, wonderful.
my lord. Lord, may I?
Yes.
On 12/4/2005, I was posted as medical officer, Taluk Hospital, Kesinga. On that date, on police requisition, I examined Nirupa Pradhan, son of Mangalu Pradhan of village Karmali, PS Kesinga, identified to me by the accompanying
Also
constable.
simple injuries.
My lord.
Oh. I think we'll apply 304, Mr. Katkia.
My lord.
Confined to already undergone.
My lord.
Confined to already undergone, we'll apply 304.
Deeply
All-
obliged, deeply obliged.
Thank you, thank you. Right. We'll pass the order during the course of the day.
My lord.
All right.
Pastor Metro weekly list item number 22.
Against the order of the learned tribunal, my lord, the observation kindly see at page 20. The observation that at the relevant time, the average ACR is below the benchmarks. The background is that, my lord, the petitioner was joined in the as an accountant on 9/5/1969. After completion of the years, my lord, he sought for an ACP. And they approached the learning tribunal. Learning tribunal has remanded for a review DPC. After review DPC, he has been declared as not entitled to get. Again approached the learning tribunal. Learning tribunal answered that it is below the benchmark valuation. So far the reason is that paragraph 11 of the annexure 1, Lord. The general rule of promotion is applied there. If general rule of promotion is there, Lord, your lordship knows that the adverse entries must be communicated to the person concerned. Here there is no adverse, but fact remains the DPC has not been challenged. The petitioner has not challenged the DPC. That is there. And perhaps the reason is best that tribunal has answered that its best mark is less at the relevant time, or which rejected the same. Kindly turn to page 11 of paragraph 11 of the annexure 1. The basic grounds that in the matter of disciplinary or penalty proceedings, it is not available here so far the present petition is concerned. But grant of benefit under ACP scheme shall be subject to the rules governing the normal promotion. That is there. And in their counter, they have sufficed that. So far my CCR is concerned is less than benchmark. That is there. And I have filed my rejoinder there also. Because this same has not been communicated. Even if it is, now the petitioner has already been retired since long.
The case of the petitioner was that he had received one promotion in the grade of senior accountant in 1986 and was entitled to one financial upgradation under the Assured Career Progression (ACP) scheme introduced with effect from 9th August 1999. Paragraph. In the first round, he approached the CAT with OA 1207 of 2002, which was disposed of on 10/2/2004 by the CAT, directing the respondent opposite parties to consider the petitioner's case by convening a review departmental promotion committee (DPC). Paragraph. The review DPC was held, but he was found not fit for ACP benefit. Full stop. Agreed with the said order, a second agree with that order dated 3rd June 2004, the second, for a second time, OA number 554 of 2004 was filed by the petitioner before the CAT. By the impugned, full stop, by the impugned order, in the impugned order, the CAT has noted that
Paragraph
the
5.
review DPC had examined all of the records of the petitioner and noted that his grading was single quotes average, which is below the prescribed benchmark, full stop. Admittedly, the petitioner has not questioned the proceedings of the DPC, full stop. While the petitioner argues that the average grading in the ACR was not communicated to him, the fact remains that for the grant of the benefit under the ACP scheme, unless he had the benchmark ACRs, he could not have been granted any such benefit. Paragraph. With the facts of the case not being in dispute, the court sees no error having been committed by the CAT. The petition is accordingly dismissed.
The appearance of Union India.
All right.
We will list item 23.
May I please your lordships? My lordship, may before proceeding, well, there is a formal substitution petition. The petitioner has died, and I have appeared to the honor that two petitioners, members of the trust board, that may be allowed, and I have appeared for them. And I am filing the consolidated cost item, and also I am filing a dead chart. Short matter. Lordship, may kindly see the
substitution applications are allowed. The consolidated petition is taken.
Already filed.
Yeah.
Yes. The lordship may see the dead chart. It's an endowment matter. Yes. On 1087, Les Itsora Panda and others filed OA number 17 of 1987 of 41(1)(e) of the OHRE Act before the Learned Assistant Commissioner of Endowments with a prayer that they are entitled to hereditarily possess and enjoy the lands of the DT. Page 1, page 11. My lord may kindly see the brief. What is the prayer? Because along with this, the lordship may kindly see page 15 of the brief, page 15, internal page 15. This is their prayer in the 41 application. Very short point. This is their prayer. The lordship got it. Page 15. The petitioner therefore pray that your honor be pleased to inquire and decide. The petitioner entitled to hereditarily possess and enjoy the schedule mentioned lands of the DT Grameswar Dev in terms of section 41(1)(e) of the Act by enjoying their respective right and duties mentioned in paragraphs 8 and 9. This is their prayer, my lord. Then, my lord, on 16/5/1991, in a 68 proceeding, the dead chart, the managing trustee of the non-heritage trust board took possession of the lands from the Inspector of Endowments of Puri by order of the Assistant Commissioner of Endowments. It is annexure 2, page 17. Your lordship may skip over. Then, my lord, this is most important. In that 41 proceeding, my lord, which is they have filed serial number 3, Inspector of Endowments was appointed as receiver of the case land by the Assistant Commissioner of Endowments in OA number so and so. My lord may see page 22 of the brief. Annexure 3. In that proceeding, Inspector was appointed as receiver. My lord may see page 22. I have given the extract of the order. Inspector of Endowments was appointed as receiver. Then, my lord, next 7/11/92, Inspector of Endowments took possession of the case land as receiver from the managing trustee. Because I have taken possession, the lordship may come to annexure 4.
So since 2008, Inspector of Endowments is in
continuing, yes, by the interim order of this court also. I am coming, my lord. Yes.
So Inspector has continued for how many years now?
Now, from that date he is continuing.
So what? Why?
No.
More than 15 years.
No. What is my prayer? Your lordship may see. I am just coming. They, after this case, they withdrew the 41 case with a liberty to file a fresh case. They did not file a fresh case. After 5 years of withdrawal, they filed a miscase. The petitioners in the 41, the possession may be handed over to us.
Anyway, it's not handed over to them.
No. So yes. So what is my prayer is the order passed by the Assistant Commissioner. Yes, exactly, my lord. The order passed by the Assistant Commissioner in this case, I was not given an opportunity and ex parte order. Your lordship may direct the Assistant Commissioner to hear both the parties and pass order who will take possession. That is my simple prayer. Yes, that is my lord. By quashing annexure.
So both of you can be heard, Mr. Mahapatra.
Yes.
My lords, I think my learned friend submitted all these things, my lords, so there is no dispute and that now at present.
Yes.
Two things, my lords, I will point out. For my lords' consideration, thereafter my lords will decide. My lords, the case has a genesis from 1970. Some of the villagers, they filed a suit that these properties are public religious endowment. That is OA number 38 of 70. And that suit, that proceeding was answered by the assistant commissioner to observation. This is a public religious endowment, and the Sevas are the hereditary Sevas. So that was confirmed in appeal. Now question comes, all these contingencies what my lord says is no problem. But thing is that endowment commissioner is these Sevas, they claim that whatever property Seva Puja we are doing, in lieu that of whatever service we are having, or we are getting enjoyment, and these properties should continue with us. In the year, what
are you? Who are you?
We are the Sevas. We are Sevas.
And who are they?
They are some villagers, my lords, in the guise of earlier one ex-trust member has come, now two villagers. So usually it happens, my lords, villagers versus Sevas, these conflicts.
We are members of the trust board. Appointed by the member
there.
That de facto trustees were continuing. That is the law.
That is de facto or de jure. Yes, is not a question. Question is that endowment
calls himself managing trustee.
Yes,
earlier he was a managing trustee for a particular period. Then dispute arose on from that date. But subsequently,
only 1 line submission.
1 minute.
1 line.
Let me finish, sir.
Yes.
Thing is that, my lords, here in this case, this period is over. Inspector endowment was appointed. Inspector endowment is still continuing as the trustee. Looking after the property trustee. Receiver. Is continuing as the trustee. Now, what my learned friend says, he has come up with a petition in the year 1986, my lords, that one of 1986, to dislodge properties from us. And this case of one of 1986 was dismissed against that you have not carved out any remedy.
We pointed all that to the assistant commissioner.
My lord, yes.
That was pointed out. Assistant commissioner has taken note of all this. Thereafter, they preferred a revision.
Expiry order.
He was not heard.
Expiry order.
They have preferred a revision, my lord, saying thereafter. That is also, they have already preferred a revision before the commissioner endowment.
That was not considered.
What kind of a class to that? Commissioner endowment.
All right.
That revision is there.
All right.
That they have given it.
20, Annexure 20.
Annexure 20. Then commissioner dealt with all this. So thereafter, that is a petition preferred by them. Thereafter, Justice JP, sorry, JP Das as then was the commissioner.
Annexure 10.
Annexure 10. He dealt with all these things. Thereafter, arrived at a conclusion and confirmed it. Yes, I understood. He was expert, hard expert, there is no problem. But accepting in respect of that, you have preferred a revision already.
No, I have not preferred.
If my lord should remind the matter to for further hearing, I don't stand in the way. But fact means I am to point out that yes, right or wrong, it might be an expert one, but subsequently you preferred revision. In the revision, you have agitated all these points. No. It went against you.
No. My only submission is in a proceeding.
I understood,
Just a minute. Inspector of endowments was appointed and taken possession from the trust board. You withdrew the case. After withdrawal of the case, just a minute. After 5 years, you filed a petition, unsuccessful, who have withdrawn the case, not filed, and the possession was directed to handed over to him. That is my whole prayer. And that miscase copy, we have no pleadings. Miscase copy was not served.
That is a correct.
Ex-managing trustee didn't appear. How can we direct it to give possession to you when you have withdrawn the case? Your prayer is that you withdrawn the case and
occasion. I am pointing out you have not settled it, and but because the owner has taken note of that, because you preferred
because you are expecting
86,
because you are expecting,
and you lost the case under section 68.
No, 68. They have told once possession is handed over, 68 should be dismissed.
That 68 you preferred that.
No,
it was dismissed because of this.
The tenure of section 68 is to take over possession. When possession was taken over by the inspector of endowment, 68 has no meaning. Yes, that is
you have not carved out the remedy.
No. Therefore, you have to challenge this order.
This is a technicality, my lords.
No, not technicality. Your lordship.
Let us not go into that. But now let us concentrate on what is the thing is
that assistant commissioner passed an order. Against that order, you have preferred a revision under section 9, and the commissioner as then was, has dealt with the matter in accordance with whatever materials possible. They have taken note of all these and categorically stated that you have lost the case on 1 of 86, and thereafter pass that order. Then if my learned friend will say that yes, it is an expert order, it is up to the milords, I leave it to milords to pass any appropriate order.
And the inspector of endowments is continued for several years now.
Now.
So let him
Now,
decide.
inspector may continue, there is no problem. Let him continue for some other days, my lords, if my lords should remand the matter. Suppose my lords remand the matter.
Yes.
But question here in this case, my lords, I am pointing out one thing. Suppose I am set expert in the court below. But against that, I prefer an appeal on fact side and law side. Revision on fact side and law side. And that fact side and law side was dealt with by the commissioner senior decision. Justice Jeffy, sorry, my lords, Jeffy Das then was the fact to High Court, sorry. Well, he has taken note of all these things, passed that order. So remanding the matter will not develop any case.
So the one thing that comes against you is you had gone before the assistant commissioner and you lost.
No, they have gone to.
That is now the second round. There was an earlier round.
No, not lost, my lord. Yes, that order, my lord, I have. Exactly, that order is not clear and land was not given. Exactly, my lord. If that order is there, what is the necessity of filing? Just a minute. What is the necessity of filing this particular thing, annexure 15, my lord, may see again? If that order is there, the finding is there, what is the necessity of these persons to file the 41 proceeding with the prayer?
1 minute. As far as you are concerned,
yes,
you went under section 68.
Yes.
Before the endowment commissioner, and on 15th October 2007 in RC 13 of 2001,
yes,
you lost.
No, I'm explaining that.
And you did not challenge that order that became final.
No, that way not. My lord, 68 provision is, my lord may see, to take over possession from the sevaks. The commissioner and the assistant commissioner said, since the possession has been handed over to you and the inspector has taken over possession, 68 is not maintainable. But 68 is to take over possession. No, just a minute. In the meantime, since I have shown to your lordship that possession was handed over to me and then to inspector of endowments by the order of receiver, how 68 it will run? 68 is to take over possession. You have gone for that, challenging that. Yes, should not be handed over to the yes. Because 68 is not maintainable. Handed over to the Sabbath, that is your case in a 1 of 86. Once you are in possession, 68 will be maintainable. Once possession is handed over, 68 is negative. Now question is, my lord, that handing over possession or taking over possession, which is the consequence, ultimate consequences, that is between endowment inspector, commissioner endowment, and the servitors. And you have so third party has no role at all. And you have withdrawn the case, saying that I will file a fresh case. I will withdraw the case because it will with a liberty to file a fresh case. No, you did not file a fresh case. After 5 years, you filed a petition to take over possession from the inspector of endowment. No question. And that has been allowed. My lord may see, and the assistant commissioner say, though this has been done in an administrative side, I am doing it. Whether he has jurisdiction or not, that has to be decided also in the missed case.
You see the challenge in the present petition by a person claiming to be the managing trustee of the deity.
And the trust board members.
Or the trust board members representing the deity is to an order dated February 8th,
Annexure 8 and
2008, passed by the Commissioner of Endowments.
Assistant Commissioner.
Orissa Bhubaneswar in RC number 16 of 2001 under section 9 of the Orissa Hindu Religious Endowments Act. Challenge is also laid to the order dated 19th October 2001 of the Assistant Commissioner of Endowments. In RC number 16 of 2001. Sorry.
Miss case number.
In
Annexure 8. Serial number 12 of my date chart.
1 minute. Challenge is also to an order dated 9th April 2001.
Yes.
Of the Assistant Commissioner of Endowments, Bhubaneswar, in this case number 1 of 1999, whereby the Assistant Commissioner directed possession of the properties to the hereditary sevaks who are included in the present petition as opposite parties.
They are opposite parties, my lord.
Opposite parties for all.
1 to
All opposite parties.
1
to 14. 1 to 14.
1 to 14.
1 to 14.
No, there's also 16.
No, up to my lord 17. Up to 17. my lord.
Yeah, 1 to 17. All right. Paragraph. This court, while issuing notice in the present petition 5th March 2008, has directed that the Inspector of Endowments Puri shall remain in charge of the management of the Sri Grameshwar Dev and Sri Kanak Durga Thakurani, situated at Veer Hari Krishnapur till further orders. That interim order is continued till date. One of the grievances voiced by the present petitioner is that the Assistant Commissioner of Endowments passed the aforementioned order without hearing the petitioner. Full stop. Counsel for the opposite parties 1 to 17 on the other hand contends that present petitioners who are some villagers and not the trustees had earlier unsuccessfully petitioned the Assistant Commissioner for possession to be handed over. And the order in revision affirming the said order was not challenged by them. Paragraph. Having heard on counsel of the parties, the court is of the view that the matter should go back to the Assistant Commissioner of Endowments for a fresh hearing to enable both parties to place their respective cases before the Assistant Commissioner for a proper decision on merits. Stop. Consequently, the impugned orders are hereby set aside.
Annex 10 also.
Annex 8 and 10 both.
And the matter annexes 8 and 10 bracket are hereby set aside. And the matter is remanded to the, and this case number 1 of 99 is remanded to the file of the Assistant Commissioner for a fresh hearing on merits uninfluenced by the decisions that have been set aside by this court. Both parties will appear before the Assistant Commissioner on 2nd May 2022. The Assistant Commissioner is requested to dispose of the said miscase after hearing the parties by reasoned order within 4 months thereafter. Till such time, the interim order passed by this court on 5th March 2008 will continue. The petition is disposed of.
Obliged.
Supplementary list. Fresh admission item number 2. Supplementary list fresh admission item number 2 WPC 11948 of 15.
None appears dismissal, no prosecution.
Supplementary list item number 3.
None appears dismissal, no prosecution.
Supplementary list item number 4.
Well, it's item number 4 may be taken up any other day on behalf of Mr. Parija. It's indisposed today.
Or a counsel for the appellant is stated to be indisposed. List on 13th July.
Supplementary list item number 5.
Item number 5, may I please, Your Honor? Dear my lord, for the assessment year 15-16, the petitioner was initially assessed under 143 to nil income.
All right, we'll just issue notice. You say notice. So Chimanka accepts notice. Replies we filed within 8 weeks, rejoined up to the next date. the reassessment proceedings may go on, but no final order shall be passed till next year. That's in the IA. List on 6 July.
Supplementary list for orders, item number 6.
None appears to
My lord, item 6, no instruction.
No instructions. Ms. Post Office.
Item number 7.
Your lordship may kindly permit me to move this application. My lord, here the villagers have come up in the shape of a public interest litigation wherein the properties of the state which is recorded as jungle has been leased out to the private parties, and your lordship, the section 25(1) of the Forest Act says that no jungle kisam jami lands can be either sold, leased or given to any private individuals. I even applied for certified copies of the entire lease records. That also was rejected on the ground that no records are available. That is annexure 6.
But you don't seem to have made any, what is you are the villagers, is it?
Yes, my lord. The properties are in the middle of the village, which is Kisam is jungle.
So let them treat the petition as a representation.
My lord, I have filed an application to that effect also.
All right.
Annexure 4, page 19.
Yeah, the petitioner's application bracket annexure 4 will be examined by the collector, is it?
My lord, I have given to sub-collector.
Sub-collector Attagad, bracket opposite party number 3. And after issuing notice to petitioners and opposite parties 5 to 7. And after giving them a hearing, a reasoned order should be passed not later than 1st August 2022.
Obliged.
Let him supply the copy of annexure 4 along with the order.
All right.
We don't have the copy of the writ petition also.
Yeah,
that is
the
the
copy
defect.
of the annexure 4 along with the downloaded copy of this order will be produced by the petitioners before the sub-collector not later than 4th April 2022 for compliance.
Obliged.
Court clarifies it has not expressed any view in the matter. Right.
Supplementary list, item number 8.
My lord, the substantial question of law is at page 8, my lord.
Not framed yet, sir.
Not framed, my lord. It is first time. Under the number 2, the substantial question number 2, whether the income tax appellate tribunal is legally right to hold that no depreciation allowable to the assessee on the entire block assets falling under the head of plant and machinery, even if a portion of the same has not been used during the year.
How can you stop depreciation, sir? Merely because mining activities are stopped, the machinery still undergoes depreciation.
That has not been used.
Only the crusher unit was.
No, that's not the matter, sir. The passage of time, the machinery depreciates anyway in value. Even if it is idle, it depreciates. It's like second-hand car. Even if the car has run only 10 kilometers, it's only second-hand car, correct? You don't treat it as a new car.
The materials, my lord, which were in the use, my lord, that has been allowed.
That in use, not in use, you're not determining how many hours it has run. That is not the principle on which you determine it, sir. What has the tribunal said?
My lord, before that, the grounds before the tribunal at page 5. The ground number 4 and 6 and 7, these are relevant, which are not at all taken into consideration by the tribunal. The tribunal order is at page 21, my lord, annexure 3. And the relevant portion, my appeal considered at page 30, my lord. That grounds never they have to consider, my lord.
Obviously erroneous, sir.
Concurrent, my lord, the launch CIT also told that.
The grounds at the page.
Also kindly see page 19. That is the.
No, where do you get this use of business of the SSC? Where is that concept coming from? Why is that being doubted?
Lordship, kindly see page 19. I am reading, my lord. Although the appellant had mentioned that the above AO which the AO produced for the in the assessment order, the appellant did not clarify whether depreciation should be allowed in the rest of the assets in the block claimed by it. Apparently, the appellant did not mention any detail of the claim, my lord, against which he is claiming, my lord. Regarding the rest of the block of assets, other than only mentioning those names. The appellant did not produce the evidence regarding the payment of electricity and diesel specifically and separately for operation of the crusher plant. The appellant did not disclose any form from the iron ore fines being brought. Whether the same is brought to the plant for processing or
Where do you get this, sir? That they have to show that they paid electricity bill, they put diesel, they operated the machine. Where do you get all these as conditions for depreciation?
All those in the books of account and the PL account.
Where do you get this under the provision of the act that unless the SSC demonstrates he has actually used, he can't get depreciation? Where do you get that? Said the present appeal is directed by the SSC is directed against an order dated 4th August 2017 passed by the Income Tax Appellate Tribunal. Cuttack Bench, Cuttack bracket IT80. Dismissing the SSC's ITA number 28/CTK of 2016 for the assessment year bracket AY 2011-12. When you say admit the following question of law is framed for consideration, whether the assessing officer bracket AO, the Commissioner of Income Tax bracket appeals bracket CIT bracket A, and the IT80 were right in holding the SSC not entitled to claim depreciation on plant and machinery during the AY in question on account of non-use of the said machinery. Question mark. The perusal of the impugned order, this court has heard the submissions of Planet Council of the parties. The perusal of the impugned order of the IT80 on the above aspect shows that the depreciation was allowed on the ground that the SSC could not produce evidence regarding open quotation payment of electricity and diesel, unquote, for the purposes of operating the crusher plant and not disclosing open quotation from where iron ore fines had been brought, unquote, and evidence of open quotation processing, if any, of the iron ore fines purchased by it, unquote. Accordingly, the AO disallowed depreciation of rupees 57,03,909 only on the ground that the machinery was not used during the AY in question for the purposes of the business of the SSC. Paragraph. That the SSC owns the above plant and machinery and that it is available in the premises of the SSC. Business premises of the SSC is not in doubt. Full stop. Counsel for the Revenue was unable to show any statutory requirement that in order to claim depreciation on plant and machinery used for the purpose of business, the SSC must actually demonstrate the running of the operation of the plant and machinery throughout the year. As the court views it, there is no such requirement for the purposes of claiming depreciation. Paragraph. In that view of the matter, the impugned or the question framed is answered in favor of the SSC and against the revenue. And the orders of the AO, CIT, A and IT80 relevant to the above question are accordingly set aside. The AO is now directed to give appeal effect to the present order in accordance with law. The appeal is disposed of the above.
Supplementary list item 9. 9 and 10 limit within the limit.
9 and 10
covered by the notification.
Counsel for the Revenue points out that the tax effect is below the monetary limit. The appeals are accordingly disposed of as withdrawn.
question can be kept
The
open.
questions of law are left open for consideration, some appropriate case.
Supplementary item 11.
Note that demand is more than 4 crores 35 lakhs and question has been framed at page number 4. Whether in the facts and circumstances of the case in law, the honor of ITAT is justified in law and in view of the provision of section 36(1)(3) of the IT Act, the ITAT is justified in holding that the system has capitalized the interest on borrowed capital for acquiring fixed assets, thereby eligible for deduction when no such interest has actually been capitalized in the books of accounts for the assessing company during the financial year 10-11 relevant to assessment year 11-12. Second question is that whether in the facts and circumstances of the case, the law.
No, that's okay. That 46A we're not entertaining. What is the finding now? The ITAT on this aspect? Capitalizing interest?
ITAT allow the appeal.
No. What is the reasoning, sir?
ITAT order on the basis of the order of the CIT appeal. Page 8, the tribunal has discussed the issue and confirmed the action of the CIT appeal in deleting the disallowance made by the assessing officer by observing the agenda. We have then page 11.
Nothing in this, the present appeal is directed against. The present appeal by the revenue is directed against an order dated 3rd August 2017 of the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, IT80, in ITA number 231/CTK/2015 for the assessment year bracket AY 2011-12. The question sought to be urged for consideration by this court by the revenue reads as under. Take from page 4, para 6A. The CITA and the ITAT have concurrently held that the capital work in progress of the SSC consisted of both the captive power plant as well as the ore beneficiation plant. Full stop. The SSC had availed term loan for setting up of the said plants and capitalized the interest pertaining to the term loans for both the plants. Paragraph. In terms of the accounting standard 16 issued by the ICAI, SSC was entitled to capitalize the finance charges and interest. Paragraph. The court is unable to find any error having been committed either by the CITA or the ITAT in the above regard. No substantial question of law arises. The appeal is dismissed.
Supplementary item 12.
Lordship, in this item, I am appearing behalf of respondent. Lordship, I will mind.
No, it's just item 12 is the revenues.
11, Lordship.
All right, 11 is over, sir. Just now dismissed it.
Lordship,
Item 12. Supplementary item 12.
Item 12, my lord. At page 7, it is a 12A registration matter. Page 7. Whether on the fact and circumstances case, the learned tribunal is justified to allow the appeal of the respondent on the ground that 12A registration certificate was issued retrospectively, but at the time of assessment, no registration was available to the respondent. Second question, whether in the facts and circumstances case, the learned tribunal is justified to allow the appeal of the respondent on the ground that 12A registration certificate was issued retrospectively, but at the time of assessment.
Same, you're reading the same thing twice.
Same question 1 and 2.
Anyway.
It is not verified.
What is the ITAT held, sir?
In favor of the SSC.
Obviously, that's why you're in appeal. What
Yes.
is it? What has it observed?
Yeah, observe. page 10 and page A9. Further find now where the CIT appeal has held that the funds utilized for the making investment in temple by the SSC is to be allowed as deduction 11-12 of the Act. During the end of the appeal, depreciation temple was claimed as deduction by the SSC, which are allowed by the CIT appeal on the finding that the temple was part and parcel of the education institution and as for the benefit of all the students and the staff of the institution without any discrimination. Further find the similar
The
facts.
registration is in fact granted for all the AYs in
Yes,
question, sir.
yes.
Paragraph, you say the revenues appeal is directed against an order dated 6 July 2017 passed by the Income Tax Appellate Tribunal. Katak bench Katak bracket ITAT in ITA numbers 408 to 412 oblique CTK oblique 2013 for the AYs 2005-06 2009-010. The questions ought to be urged by the revenues whether the ITAT was right in upholding the order of the CIT bracket A that the registration certificate issued to the SSC under section 12 capital A of the Income Tax Act 1961 was valid for all the AYs in question and could therefore be given retrospective effect. Paragraph. Having perused the orders of the CIT A and the ITAT, the court finds that the revenue is unable to point out why the benefit of registration under section 12 AA of the Act, which had in fact been granted to the SSC for all the AYs in question, was denied by the AO. There is no error pointed out either in the order of the CITA or the ITAT that gives to any rise to any substantial question of law. The appeal is accordingly dismissed.
Supplementary item 13.
My pretty pleasure, Lordship. That is the business is carried on grocery wholesale, whereas they have estimated profit rate 10%. Subsequently, it was reduced to 7% by the CIT. That was upheld by the law tribunal. Now the question arises when wholesale business are generally rampant, 2% profit is generally adopted. So that has not been taken up here. In this case,
all this is not no substantial question of law, sir. This is all not substantial question.
Only one question raised before your lordship, that is whether in the law tribunal legal justified to uphold the profit rate, which could
2%,
have been
7% and all, we're not going to entertain. Sorry. This is an SSC's appeal against an order dated 26 May 2017 of the Income Tax Appellate Tribunal in ITA number 44/CTK/2017 for the assessment year 2009-10. The question sought to be urged by the SSC for consideration is whether the ITAT was justified in upholding the profit rate at 7% of the turnover, whereas the SSC was asking it to be limited to 2%. Paragraph. Having heard learned counsel to the SSC and having examined the infant orders, the court is not satisfied that any substantial question of law arises for consideration. The appeal is accordingly dismissed.
Supplementary item 14.
14 is same, my lord.
For the reasons stated in the order passed today in ITA 103 of 2017, the present appeals 4, 5, 7 all dismissed. Right.
No, my lord.
15.
15 is two penalty under section 271. That is concealment. In this case, my lord, its cover matter is there because amendment petition has already been filed. When they are issuing notices that concealment or furnishing inaccurate particulars, in this case, this honorable court has given a decision. They are not sure whether inaccurate particulars or concealment of income. So levying penalty without deciding thing. So this is the
271(1)(c).
271(1)(c). Two things are there. They have to decide concealment, whether due to unaccounted profit or concealment of income. They have not decided. So when notice was given without cutting the session. This is our honor. This court has decided the order in 10/4/2019.
Who's for the
Yes.
covered?
Covered, but the fact remains not page 13. He has not, these are detected by the authority. He has not explained the bank entries. So it amounts to be in the concealment.
Still they have to apply in their mind and come to the conclusion, sir.
No, kindly see page running page 13.
No, the notice should say whether it's concealment or inaccurate. The notice doesn't say, it's like leaving all that.
Yes, correct.
We say in view of the order dated 10th April 2019, in ITA 30 of 2005. Actually, first line you have to say, 107 is the same thing.
Same other partner.
Okay, 10.
271.
271.
It is
No, 105, ITA 105, 107 are same.
No.
Different matter.
That is another penalty. Another penalty that is limited 25,000 they have made because.
Correct. In 105, you say this is an appeal by the SC against the order dated
We should not have.
26th May 2017, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack. Bracket IT 80 in ITA number 42/CTK/2017 for the assessment year bracket AY 2009-10. Admit the following question of law is framed for consideration. Let's take question 1, page 5. It's in view of the order passed by this court on 10th April 2019 and ITA 30 of 2005, bracket Ananta Gopal. Karatakala versus ITU Baleshwar. The impugn order of the AO is upheld by the CITA and ITA. I have set aside. The appeal is allowed in the above terms. The question of law is answered in favor of the SCC and against the department. The appeal is disposed of.
16. Supplementary 16.
16 is 10.
16.
271 here.
That is something different.
No books of account maintained.
28,000 not, yes.
25,000.
And that is he has not produced the books of account and concealment is there, therefore.
Fine, penalty is 25,000.
Yes.
Considering the insubstantial sum of amount penalty imposed on the SSC, the court is not inclined to frame any substantial question. Is of the view that no substantial question of law arises in the present appeal by the SSC. The appeal is dismissed.
The 13, 14, 15, say I am appearing.
Supplementary list item number 17.
Please, kindly let the matter come day after tomorrow because Mr. Bibag is engaged in this case and he will
tell us what it is, sir. You have the paper book.
Hello?
You have the paper book.
I don't have any paper book, my lord.
We have the paper book. Let us help us. We're not adjourning. Give me the paper book.
My lord, the matter is relating to the illegal
let us see that. Come.
Illegal mining query.
All right.
In
Let's see
2000.
that. Let's see that.
The matter is relating to illegal mining query, my lord.
Or
in 2013, in Saha Commission has stated in his report that opposite party number 8 and 9 are involved in this case, my lord. And they violating the guideline of Supreme Court, my lord, the rules of OMC rule, my lord.
You had already filed an earlier writ petition.
Earlier writ petition were filed before Supreme Court and the Supreme Court has remitted back to this High Court with liberty to file application before this honorable court, my lord. And we had given a representation, my lord. Representation which annexure 8, my lord, 8 series, my lord. What happened in this case, my lord? In spite, there is a criminal proceeding also pending before the opposite party number 8 and 8, my lord, who is the director of the opposite party number 9, my lord. in spite of having the criminal, thereafter one criminal proceeding was initiated against him. In spite of pendency of criminal proceeding, from 2015 to 2020, the lease period was extended. And who is the director of the opposite party number 9? He is the same director of the opposite party number 10, my lord, GM Iron, who the director has not environmental clearance also, my lord. And kindly glance
You
at
have
my lord.
instructions, Mr. Mudli.
No, you lordship, kindly turn to page 14. Well, in fact, this inquiry was conducted pursuant to orders issued by the Honorable Apex Court by Honorable Justice Saha Commission, and report was submitted before the Honorable Apex Court. Thereafter, you lordship can see, on the basis of report, criminal proceedings have been set into motion.
But he's continuing to operate, he says. Despite all that, this mining is continuing.
No, lease has expired.
But is the mining continuing?
No. That source has been put to auction, and again in the auction, in the bidding process, the opposite party number 2, which is a new entity, he has taken over the.
Who is the new entity? Who's the new entity?
10.
Opposite party number 10.
Opposite party 10. Who is
Same director, he says.
My lord.
Same man has come in.
My lord.
How can you allow the same person to come in, sir?
Earlier, the lessee was OP number.
He says the director for both is the same.
Right. One criminal proceeding also pending against the director.
You just say notice, Mr. Mudli accepts notice for opposite parties. 3,
4, 6, 7.
6 and 7. Notice will now issue to opposite parties 1, 2, 8, 9 and 10. 1, 2, 5, 8, 9 and 10. Sorry, 7, 8, 9, 10. Oh, 6 and 7 you are taking, right?
Yes.
8, 9
3,
and 10.
4, 6, 7.
The registered speed post returnable on the next day. Replies be filed within 4 weeks in service of notice joined up the next day. Just on 21st July.
Item 18. Supplementary list item number 18.
None appears as person wrong person.
Supplementary list item number 19.
My lord, I have an issue visible. This is matter. This is
Supplementary list item number 19.
I'm audible, Lord?
Yes.
Yes, this is a matter. It's a public interest litigation, Lord. Here the petition.
There's no proof of their
yes,
representation being delivered.
Blood last Anisha 3, Lakshman Anisha 3, page 12, Lord. Page 12.
What does it say?
This is a letter issued by the person to Anisha 2, Lord. The additional district magistrate.
The petitioner's grievance in Annexure 2, which has been forwarded by the ADM Subarnapur under Annexure 3, shall be examined by the State Pollution Control Board.
Yes, Lord.
Opposite party number 2. And after issuing notice to the petitioners as well as opposite parties 6 and 7, the reasoned order shall be passed not later than 9th May and be made available to the parties not later than 16th. Court clarifies it is not expressed in the
No, within a stipulated time, Lord. So
it said that.
Supplementary list for admission item number 20.
20 mellows here on the last date I was arguing, Melot had given one chance since respondent did not appear. This is a case where the learned labor court's order is under challenge. Here, my lords, the order date is 6/2/2007, and my main grounds of challenge at first is that the reference was made at a very belated stage after a long lapse of 11 years, my lords. And the claim statement was filed by the workman even after a period of 15 years in the year 2005, my lords. 2005, wherein the dispute relates to the year 1991. At that time, the workman was under the establishment of Orissa State.
It's not appearing.
My lord, pardon, my lord.
Mr. Kanungo.
Kanungo is the senior counsel appearing for respondent, but I think he is not appearing today.
My lords, I am appearing for the opposite parties, my lords.
Tell us.
Yes, my lords.
Tell us, please.
Yes, my lords. The delay point, my lords, basically they have taken the delay point, the filing of the case before the labor court, my lords.
Yes.
So they are saying it's 11 years delay, my lords.
Correct.
In their, but they have stated that as if the case has been filed before the labor court. Actually, this is a reference case, my lords. His case was not filed directly before the labor court, my lords. The 282, my lords, the 282, there is a, my lord, 283, my lords, which is introduced at the year 2010, my lords. If a person raised a dispute, if it continues more than 60 days, then directly he can file a case before the London Labour Court.
No, but doesn't mean you can wait for 11 years and file.
Yes, my lord.
How does it mean, please?
Yes, my lord.
Everything has to be done in a reasonable time.
Yes, my
Everything has
lord.
to be done in a reasonable time, sir.
Yes, my lord. Just
What is the explanation for 11 years?
Yes, my lord. I'm coming back. I'm coming back. So, my lords, after refusal employment, my lords, time and again I approach them.
That is not good enough, sir. This time and again doesn't help. You must explain properly the delay.
Yes, my lords. Yes, 46. The lordship may kindly come to the page 46 of the recapitulation, my lords.
Yes.
That, my lord, the failure report of the conciliation officer, my lords.
So you're not explaining the delay, sir.
My lord, I raised the dispute on 6th August 1997, my lords. The dispute was raised before the conciliating authority, my lords, on 6/8/1997, my lords. And I was refused employment on 1991, my lords. So thereafter, my lords, I approached the concerned executive engineer. So he told me in the next month it will be considered. Thereafter, next year, likewise, when ultimately, when there is no relief, my lords, I raised the dispute on 1997, my lords. That is also the failure report that is there, my lords. Thereafter, my lord, the matter was referred to the Labour Court, my lords.
This thereafter seems to have no time limit, sir. Your thereafter means another 5 years is gone. The reference to the Labour Court was made in 2002.
Yes, my lords.
Your dispute started in 91. You seem to have a very expanded notion of time, sir, your client.
My lords, actually, the 2002 to 2005, my lord, there is no explanation for that. But
where is he?
But refusal employment in 91 and
claim statement has been filed even after further delaying. In the year 2005, he has filed the claim.
Claim statement in 2005.
5, my lord.
Yes, my lord, 2005.
No satisfactory explanation has been given, my lord. That is the whole.
You say there appears to be a delay at every stage of the proceedings, leading to the filing, the passing of the impugned award dated 6th February 2007 by the Labour Court. Sambalpur in ID case number 38 of 2002. The dispute referred to the Labour Court for adjudication. Read as under, reproduce that from page 11. One of the principal grounds of challenge to the impugned award, whereby the Labour Court has directed reinstatement of the workmen with full back wages, is that there is inordinate delay in the workman approaching the statutory machinery for relief, invoking the statutory machinery for relief. Paragraph. Having heard learned counsel of the parties, it appears to the court that the workman did not seek to invoke the statutory process till 1997, although his alleged illegal termination took place in April 91. There is no satisfactory explanation for this delay. Then again, the actual reference to the labor court was made only on 10th May 2002, that is 5 years after the failure of the conciliation proceedings. This delay is again not satisfactorily explained. Worse still, the statement of claim itself was filed only in 2005. That is 3 years after the making of the reference. Paragraph. With that being delay at every stage of the proceedings, the labor court ought not to have proceeded to adjudicate the case without deciding the basic issue of delay in the workman approaching the statutory machinery for relief. Paragraph. For the aforementioned reasons, the impugned award of the labor court is hereby set aside. The petition is allowed, no other sister cause.
Supplementary item 21.
Submitted two memos.
Can't hear you, sir. You'll have to speak louder into the mic.
Yes, I have submitted just two memos stating that the sole petitioner has died.
All right. Whenever said not, we don't know about all this.
Lords,
When did he die?
that I have to inquire.
No, you make your own inquiries whenever you want to.
Then
Counsel
may I
the
pray?
petitioner states the petitioner has died.
May
Does
I
not have
pray?
any information on the date of death of the petitioner even. The petitioner is disposed
May I
of his
pray,
affidavit.
my lord, one thing? May I pray one thing? I pray, let it be disposed of with liberty for the legal heirs to approach affairs.
That liberty is always there, sir.
No. Once writ is filed by the deceased father, therefore that I want.
All right.
With that liberty, I don't want.
Right.
May that liberty be given.
Supplementary list item 22.
Yes.
My lord, not pressed, my lord. The
Counsel,
petitioner has
petitioner
returned
states
from
the petitioner is not pressed, disposed of as not pressed.
Supplementary list item 23.
I will please your lordship. Here in this case, my lord, the petitioners have challenged the recruitment to the Group D post of London District Judge Baleshwar, my lord. Lordship, kindly turn to page number 7, annexure 1, wherein there was an advertisement for 27 posts on the schedule caste 2, schedule tribe 5, SCBC 8, on reserve 12, and total number of 27. First count of my challenge that reservation cannot be more than 50%. Second, Lordship, kindly turn to page number 50, the merit list, select list, wherein the advertisement was for 27 people, but the merit list, appointment list was made for 47 people. These are the two basic grounds of my challenge of the illegalities committed by the recruiting authority.
All over, so the selection is over 2013.
My lord, but any appointment, there is an interim order by this honorable court, any appointment subject to the result of the writ application.
All right, tell us. What is it?
Any appointment shall be.
I know that. Tell us what is wrong. What did you say is wrong with this selection?
So wrong with the selection is that, my lord, the appointment, this advertisement was made for 27 candidates, 27 seats, to fill up 27 seats. Annexure 1, page number 7. And the reservation was made for 15. Out of 27, reservation was made for 15, which is beyond, contrary to the law laid down by the apex court that no more than 57 reservation.
No, there's no such rigid band, sir. Generally, it should not be more than 50. That's all.
Oblige, my lord.
There's no such rigid. In fact, state to state, it all varies.
Oblige.
In some states, there is even 67% reservation.
Yes, my lord. Then my second objection that when the recruitment was, advertisement was not made for 27, but the appointment select list was made for 47.
It must be the wait list or something.
No wait list, my lord. That is appointment.
What is your instruction?
Well, we have stated in our counter that there were two lists were done. First list was for 27 numbers of candidates are enlisted, first in the descending order of merit, and below them place the waiting list of remaining
That's
22
what-
numbers.
There are two
Madam,
grounds on
count-
which the
count-
selection
Madam, counter
made
is not solved.
pursuant to the advertisement issued on 21st. No, the select list of dated 21st July 2013.
And all those persons are not
for
parties
filling
to
up
the
group
request.
D posts in the court of the civil judge Balashore is assailed. One is that the reservation was more than 50%. There is no rigid rule about reservation not being more than 50%. Here, of the 27 posts, 15 were reserved. Most of the court does not find this to be an illegality that requires
And knowing
interference.
this condition, he has also participated.
Second ground on which it is challenged is that although there were only 27 posts, the select list contained 47 names. There's been explained in the counter affidavit that names below the 27th name were all in the select list, in the wait list. That view of the matter, there's no merit to this petition, it's dismissed as such.
Supplementary item 24.
None appears, dismissed for non-prosecution.
Supplementary list item 25.
Well, item 25, last occasion, my lord, directed to obtain the instruction. I have requested the department, they have requested for some more time.
All right. At the request of Mr. Mudali, who needs more time to comply with the previous order. List on 18th May.
Supplementary item 26.
This is one last time your lordship directed Mr. Mahapatra, counsel to the petitioner, to visit the park and playground and submit.
I think no order
No,
from
no.
me, my lord.
My lord, on last occasion, the petitioner was directed.
Yes, yes.
My lord, it's a case where the Biju Patnaik Park situated at CDM.
So I wanted you to go and
In
visit.
the meantime, my lord, Mr. Mahapatra has been appointed as member of State Consumer Commission. Your lordship may direct me or any other.
We should direct you or anyone preventing you, sir. We are not acting on our directions. Who prevented you from walking into the Biju Patnaik Park and taking photographs? Why do you need permission? It's a PIL after all.
My lord.
Why do you need permission, direction, all this? If you're really interested in the issue, you should go visit the park yourself.
Within 2 weeks, I will file my lordship.
What's your name, sir?
DP Mahapatra.
DP Mahapatra states that he needs more time to visit the park and place affidavit with photographs of the court. At this request list on 18th April.
Supplementary item 27.
Please, your lordship, it's a public interest litigation. There is a village called Dadapatna in Barang subdivision under Cuttack district, very proximate and close to this honorable court. Earlier on some government land, there was a vocational training center for physically handicapped people, special, and subsequently, and with the support and aid extended by the Social
counselor.
Empowerment Department. And in that
Who's
connection,
appearing? 1 minute, sir. Who's appearing? State Council.
Yes.
Somebody should appear.
My lord.
122. The records have been misplaced.
Just supply one more set of the papers. One more set of the paper book be supplied to Mr. Mudali or
Yes.
Mr. Manti, Mr. D.K. Manti, to enable to obtain instructions.
in this case, the state has
11th
filed
May.
the counter and we have also filed a rejoinder to that.
All right.
All these things. I will
List on
submit.
11th May. All right.
Supplementary item 28.
I will get the copy from my
Please,
learned
Your
senior.
May I please, your lordship, last time your lordship state to take instruction, I submitted the prisoner on 27th July 2016, submitted a representation before the collector worker, my lord. No action whatsoever has been taken by the opposite party in the representation. Last time your lordship state to take instruction.
Madam, where is the proof of delivering this representation? That was the main question.
This matter relates to, the allegation was made that non-payment of crop loss insurance.
Anyway, there's no proof of this representation being delivered to anyone.
In fact, I have filed the counter affidavit. You also can see counter affidavit filed by the opposite partner 5 and 7. There you also can see paragraph 4. They stated that 19 crores 51 lakhs 30,736 have been paid to 25,541 affected farmers. Paragraph 4 of our counter affidavit of the opposite.
All right. In paragraph 4 of the counter affidavit filed on behalf of opposite parties 5 and 7, it has been stated that a total of 19,51,30,736 has been paid by the government to persons who sustained crop loss during the Kharif season 2015-16 due to inadequate rainfall. First of all, it is stated that the number of affected farmers to whom the amount has been paid is 25,541. They've been given input subsidy. And the total allotted amount of 1951, the aforementioned allotted amount has been disbursed in full. That view of the matter, no further directions are called for. The petition is disposed of.
Supplementary item 29.
Mr. Mahanti is absent as because his our wife is expired and it may be urgent to.
What is the matter about, sir? You tell us. You help us, sir. You tell us what the case is about.
I have no knowledge and I don't have the file.
ROR holders for relief regarding entries in the ROR, there are adequate statutory remedies for which the court does not propose to entertain any PIL. The petition is disposed of.
Supplementary item 30. Supplementary list item number 30.
None appears dismissed for non-prosecution.
Supplementary list item 31.
May it please your lordship. My lord, this is a PIL filed for a direction to the state government to install nucleic acid amplification NAT mechanism in all the blood banks for detection of HIV, HCV and HBV infections in the blood received from the donors.
The counter has been filed.
Yes, and in earlier this honorable court, where a judgment in the year 2011 had also directed to do so. Your lordship may just kindly see page 14 of my writ petition.
We'll take it on some other days. List on 21st June.
Supplementary list item number 33.
May I please? Lordship, I'm answering to your lordship. In this case, my apologies for delayed submission of my rejoinder, and that is not come on record, your lordship.
Where is it?
I filed the rejoinder yesterday only.
All right, the rejoinder filed with the petitioner be placed on record. List on 19 July.
Lordship, can I pray for a shorter date?
Sorry. Yes.
Supplementary item 34.
34, your lordship, kindly allow me 3 weeks time to file the rejoinder, your lordship. Today I have received.
Rejoinder be filed before the next date. List on 26th July.
Supplementary list item 35.
May it please your lordship. My lord, I have filed a report at flag 20. 2 incidents had happened in Devi River mouth area, which is in Puri district, and where the turtle mortality is very high, about 80% of the mortality takes place there. I filed a report it's at flag 20, annexure 1, page 4. On 26th of December, there were 2 fishing trawlers from West Bengal fishing in the prohibited zone. And when the fisheries department and the forest officials apprehended them and tried to bring to the coast, the Astarang Marine PS, which under whose jurisdiction it falls, they did not cooperate, for which the trawlers managed to escape. And
I think this we already noted in the earlier order.
Your lordship had directed me to file a report on it. They managed to escape, and only the 9 crew members were detained. And accordingly,
you have a copy of this report that he's prepared.
Yes, I have given them.
We have filed also response to that report on 7th. It's not there. I'm filing the hard copy.
And then, yes, I have got it. And then secondly, on 31st of December 2022, there were 20 trawlers fishing within the prohibited zone. And due to the non-cooperation of this Astarang Marine PS, the forest department and the fishery department, they could apprehend only 4 trawlers and the rest managed to escape. Lordship will see, this was the peak season where the congregation and mating was going on. And this is bound to kill hundreds of the olive trees there. The official figures may or may not come. But this was the main peak season during which this happened. And due to total non-cooperation of this Astarang Marine PS police officials. Even the fishery department has sent the report to the home department that something needs to be done.
But there's been no other incident after that, correct?
My lord?
After this 26th December, there's been no incident.
It happened on 31st of January, again, where 20 trawlers were found fishing inside the prohibited zone.
No, but what happened?
My lord?
No. The 20 trawlers, what happened 31st January?
Only 4 of them could be apprehended and the rest managed to escape.
This affidavit doesn't talk of 30th January.
The second incident, I believe they have not written anything about that.
No, they have, para 9.
Paragraph 9.
They also agree with you?
Yes, my lord.
What needs to be done, Mr. Mudali, to strengthen this?
We are taking steps, and we have also
many of them escape very easily.
That also search is going on to trace out all the
They will never be traced out, sir. Sea is too vast.
See, page 3 of my report, actually, they are working even less than 50% of strength. I have given a table at page 3 of my report. Just for an example, I have taken this Talchua Marine PS, the sanctioned strength of the officials, police officials there, and the vacancy position. Even less than 50% are working.
That I will take instruction.
You better not instruction. Fill it up, sir. Fill it up.
Para 8, I have prayed before your lordship that appropriate inquiry may be caused by the ADG Coastal Security into the conduct of this police officials, because even earlier, the last time in the Gahir Matha incident, they damaged the fishing boats and everything, and it just remained on paper only. And here also,
they're outnumbered, sir. They're as simple as that, just outnumbered. Apparently, those boats are much quicker. These guys cannot even chase them. That's the whole problem.
Yes, your lordship.
You see, the amicus curiae has filed a report on the 2 incidents that have taken place in the jurisdiction of the Astaranga Marine Police Station. One on 26th December 2021 and the other on 31st January 2022. During both incidents, of the several trawlers that were encroaching into the area, only a very few could be apprehended. Stop. Although a response has been filed by the state government to the report on 7th March 2022, by and large admitting to the above facts, the concrete steps that should be taken for preventing such incidents in future has not been indicated. The amicus curiae pointed out how more than 50% of the posts in the Astaranga police station
in all the marine police stations.
In all the marine police stations lie vacant. Would stop if the government has to be serious about deterring incursions by trawlers into the protected marine sanctuary, is it? Is it a marine sanctuary? What is it called?
No, my lord, this is a prohibited zone.
Into the prohibited zone. Into the prohibited zone. Concrete steps need to be taken to ensure that these vacancies are filled up in a time-bound manner. Paragraph Mr. P.K. Mudali, learned AGA, states that the response of the state government in this regard, in the form of an affidavit setting out the time-bound concrete steps, will be filed before the next date. 27th April.
And
I
so
think
let the-
26th April. 26th April.
And let the state also inform the status of installation of transponders, because we have to
On the
depend
next
on
date,
that.
the state
only.
will inform the court of the status of installation of
Transponders.
Gohiramata is completed, and so far as this.
Stated on affidavit.
That is
Stated
going
on affidavit. All right.
Supplementary item 36.
I am for the petitioner that the impugned order is at page 86, annexure 12. Your impugned order is at annexure 12. What happened, it is arising out of a Sairat case, but your lordship can see the
Sub-collector's order is appealable, sir.
sub-collector order is not appealable.
Why?
Sub-collector order passed in an appeal. By virtue of your lordship's direction, we have gone to the sub-collector and filed the appeal, and the sub-collector has disposed of the appeal, rejecting our appeal and upholding the advertisement that it is legal. And in another appeal, the same advertisement was challenged before this honorable court, and your lordship directed that we should file the appeal before the collector. The collector has hold that that advertisement is illegal because that has not been published in the 2 Delhi newspapers, and there was no 15 days clear notice. That I'll place before your lordship. 2 writ petitions are filed before this honorable court in the same advertisement. At annexure 2, your lordship can see on 4/3/2021, 2 Sairats so have notified. That is at page.
All right, sir. We just say notice. Mr. Mohanty accepts notice on behalf of opposite parties 1 to 5. Notice to opposite party number 6 by registered speed post returnable. On the next.
I am already there.
Mr. Ratha accepts notice. Replies we filed within.
I will serve the copy on Mr. Ratha with your private
All
appeal.
right. List on 10th May.
That the operation of this hand Sairat may be state.
No.
Because that notification has been held to be illegal.
All actions
By the
taken
collector.
meanwhile will be subject to outcome of the petition. Right.
Yes.
Supplementary list item
Lord, in the
37.
connected matter, the interim order be extended. That's the.
Interim order to continue in that connected matter.
Lord, that the same advertisement has been held to be illegal.
Lord, may I
By the
just make a further prayer?
Yes.
Subject to if Lordship permits me, there is one more connected matter, that is WPC 34851 of 2021. That may also come on that same date.
List along with 34585.
No, 34851.
34851 of 2021.
That other matter is another matter is not challenging the order of the collector. That is also there.
Mr. Sahu wants to stop me in any way, by any means.
No.
Okay. All right.
Supplementary item 37.
Wait, please, Milord.
That I will supply that readily not available that writ petition, the number of the writ petition I will supply to the court master.
I have received the counter in this, Milord, so I.
All right. Rejoin to be filed before the next date. Is it connected to any matter?
No, my lords. No, my lords.
All right. List on 4th May. All right.
Interim orders to continue.
Continue. Yeah. Interim order to continue.
Supplementary item 38.
It may please, your lords. My lord, I am filing an interim application. Your lordship granted the interim order on by the order dated 28/1/2022 to maintain the status quo. I served the copy of the said order on video. Golgod. He said that this is an ambiguous order. I will not stop the construction, my lord. Your lordship kindly see that order, my lord. I served the copy on, given in the my sketch, my lord. On 2/12/2022, I served the copy. Annexure 2, my lord, along with the writ petition. I have taken the specific aberment on that, my lord.
Status quo shall be maintained, you said.
They said that as plot number, khata number, Mauja has not been provided, it is an ambiguous order, we will not stay the construction.
All right. Notice this taken on board, be numbered. Notice Mr. Mohanty accepts notice. The further construction of Gediapati Gram Panchayat Kalyan Mandap on plot number 298 under Khata number 246 of Mauza Gopalpur shall remain state till the next. All right.
Supplementary item 39.
39, my lord, your lordship has directed the Assistant Solicitor General to take instruction as to
My
why.
lord, in this case, I sought instruction, which requested some time. Lordship may some other day.
Your lordship has directed to take instruction as to why disciplinary proceeding has
Yes,
not
yes,
been.
yes. I take instruction. They are on the process of.
All right, Mr. Padi seeks some more time for instruction based on 11th April.
11th.
My lord, 11.
Supplementary list item 40. Item number 40.
Item P. In this case, my lord, I am receiving the brief from the legal and just tomorrow 5 p.m. So I pray some time will be granted to prepare this brief. My lord, this is the legal and brief.
Counsel for the appellant needs some more time to get ready with the matter. List on today is 16th March.
Supplementary list item 41. Item number 41.
Mr. Katkia, what's the position here? 41.
Case of plus direct evidence.
No. This is a jail appeal. He's still in the jail.
Jail to appeal, my lord.
What? How many injuries, sir?